have to have our Gallivan conference on this subject, but because it was such a crucial case and such an important case in the perception of law, not only for lawyers, but for so many other people. My favorite story was told to me by Elizabeth O'Donnell, the wonderful student who's helping to organize this conference, who was in high school when the case was decided. And her high school project, all the students had to figure out a law that they would propose and justify it. And everybody wanted their law to be regarding KELO, and everybody wanted to reverse the effect of the Supreme Court decision. But I think in this conference today, we're going to discuss not just or not even primarily the constitutional law. We're going to talk about what KELO means for communities, for individuals, for planners, for the people trying to figure out how to make our society work better for everybody. And so I'm thrilled with the panelists we have here today. We've got not only the lawyers that worked on the case, but leading planners, the law professors we have, all of them have other expertise as planners, as architects. We have economists, we have sociologists here to get beyond the particular facts that became so famous, to figure out what eminent domain means for communities in general, what it means for disadvantaged communities, what it means for economics. And I think that this is very in keeping with the purpose of the Thomas F. Gallivan Fund. So Professor Gallivan was a longtime property professor here, but he was also a leader of the land use law and title insurance law community. It's said about Professor Gallivan that if you asked him a question about the law, he would always know the answer, and if the answer wasn't right at the time, it would soon become so. And so his students and his colleagues wanted to endow this fund to bring together practitioners and scholars on the issues that affect us all, and I hope that you will think that this conference does that today. And before I'm going to introduce the illustrious panelists on the first panel, I just wanted to quickly introduce the chairs of the subsequent panels, because they're going to introduce everybody else and nobody's going to introduce them, and they are some pretty awesome chairs. So Dwight Merriam, the head of Robinson & Cole's land use law section, but also a dean of lawyers and planners across the country. He is the author of 9 books and over 200 articles, and has led national associations on both planning and on real property law. Professor Sarah Bronin, who has degrees from Yale in law and Oxford and University of Texas in architecture, who is already the author of several books and many important articles on, what? Okay, are you correcting me? On historic preservation and land use and environmental law. She is a new associate reporter for the restatement on property that's being planned now, as well as the chair of Hartford's Planning and Zoning Commission. And Stephen Ross, Professor Stephen Ross at our economics department, who is an amazing scholar in discrimination and urban economics, and the head of a 2000 HUD study on housing discrimination. And Stephen's not here yet because he had a kind of car tire explosion last night. One of the reasons that I'm so grateful that these amazing panelists are here is because of all the mishaps that happened to them. So one of the mishaps is that Scott Bullock, the senior attorney from the Institute of Justice, who's the one that actually argued the KELO case, had a thankfully minor car accident at the end of last week, so he's okay, but he couldn't come here today. I know that Philip Tegler came home last night to find his basement completely flooded. So we've had 3 minor disasters among our panelists, and let's say that bad things come in threes, and we're done with that. So to introduce our panel, and this panel is going to be transcribed, and the remarks are going to be published in the Connecticut Law Review because of the great interest that I think that folks will have across the country in them. And first, Tom Londrigan is going to speak. He was born and raised in New London. His grandfather owned 2 houses in the Fort Trumbull area, one which was taken for railroad purposes back in the early 1900s. He still lives in New London. He was the New London Director of Law between 1992 and 2011. He is still the town attorney for Stonington. From my other field of Indian law, he is also a longtime judge for the Mashantucket Pequot Tribal Court, and he was involved in this case from the very beginning. Then we'll have Clark Neely, senior attorney for the Institute of Justice, in Scott Bullock's stead, but he had a lot of involvement in the KELO case, and he has represented property owners and entrepreneurs in 20 states. He also, in a private capacity, was the attorney for the plaintiffs in Heller versus District of Columbia, the famous gun rights case. And finally, last but not least, Wes Horton, who I think we could say you're the leading appellate lawyer in the state, certainly. And he has argued hundreds of cases before the Connecticut Appellate and Supreme Court. So many, this will just give you an example. He's going to have to duck out of here after the panel because on Monday he's got 2 Connecticut Supreme Court arguments. And so in addition to arguing the KELO case in the Supreme Court, he also was the attorney for the plaintiffs in Sheff v. O'Neill, our famous desegregation suits, and is a fabulous professor here of appellate advocacy. So with that, I'll turn to Mr. Londrigan. Thank you very much.
Thank you.
Thank you.
Thank you, Professor Berger, and also thank you to Elizabeth O'Donnell for getting us all here together. I wanted to tell you about the KELO case from New London's point of view, from the city of New London. My role was an advocate for the city of New London, an urban city struggling to succeed in 1997, 1998 time period. I was just a municipal lawyer. I was handling everything a routine municipal lawyer would do. And along came the KELO case. I am going to leave the esoteric nuances of constitutional law and the taking clauses to others. I remember my first conversation with Scott Bullock. He said, "Tom, do you have a developer?" I said, "No, I don't think we do." He says, "Well, then your taking is based on speculation. That's clearly unconstitutional." So I said, "Well, maybe we do have a developer. We could have one in the works. Yeah, we got a developer. You have a developer?" "Yes." "Well, clearly you're taking property from A and giving it to B. That's clearly unconstitutional. You better give up." Well, I'm half Irish and I'm half Sicilian. I don't give up. But I knew at that point I'll probably need Wes Horton somewhere in my life. So as I look back to that 1997, 1998, when this process began, I begin and end with the KELO case with the role of the state of Connecticut. And let me tell you why. The tax structure for the state of Connecticut is such that cities and towns must balance their budget on the real estate taxes of their grand list. They have no other sources of income. It's got to be borne by the taxpayers on the real estate. New London was no exception. We had to look to the grand list for monies for education, police, fire, public works, and all towns and cities do this. However, urban centers have other responsibilities that towns in the suburbs do not have. Urban centers have the added social issues of our society that they must address the needs of the poor, the disabled, and the disadvantaged. These issues concern the homeless, unemployment, mental health clinics, drug clinics, transitional housing, and all types of housing. It is in the cities like New London that you will find low-income housing, Section 8 housing, subsidized housing, affordable housing, senior housing. Such uses and businesses are not high tax generators for income for the municipality. In fact, it can be argued that the cost of services to these users and residents far exceed the amount of taxes derived. Such is the plight of urban centers, such was the plight of New London. You contrast this situation with suburbia. Certainly suburbia isn't going to provide that variety of housing that I just listed. They're content, in my humble opinion, with the 2-acre zoning, 3,000 square feet homes. And by the way, give us the large office parks, give us the shopping malls and the industrial parks, bring us the big, clean development economic engines, and we will be happy. We'll accept them. Suburbia is not likely to accept the social clinic programs for the poor, the disadvantaged, and the needy segments of our society. I was an advocate for an urban center. I wanted my city to be able to compete for these large tax-generating developments, like industrial parks, like office parks, and shopping centers. Because with those big economic engines in the city, we would be better able to balance our budget and to service the social programs that we do accept in New London. However, I quickly learned we can't even begin to compete for these projects because the city of New London, like most urban areas, did not have large tracts of land for development. We didn't have large open space, farmlands and forest that could be developed. So since the 1890s, New London has basically been divided up into small lots, 50 by 100. The question becomes, how does one assemble large tracts of land to compete with our friends in the suburbs for development that will produce taxes? Well, chapters 130, Connecticut General Statute, the Blight Statute, and chapter 132, economic development, give the cities this opportunity. Now, New London has always been willing to take on these responsibilities and to provide the services that we have to provide, but the tax structure made New London look to increase its grand list. You know, in law school, from the first day, lawyers are taught that the facts determine the rule of law. And you change the facts and you might get a different rule of law. I remember Dragnet series, ma'am, just the facts. Just give me the facts. That's all I want. Professors seem to just walk around and say, well, what if we change this fact and what if we change that fact? So what are the facts? What are the facts that presented New London when it came to approve this municipal development plan? At the heart of the KELO case were 3 major events that occurred in New London within a short period of time. 2 of them positive, 1 negative. Let me address the negative. The first negative event happened in 1996. The United States of America, pursuant to the Military Base Consolidation Plan, otherwise known as BRAC, closed the Sound Lab in New London. And New London, this is right there is the underwater Sound Lab. We lost 1,800 high-paying professional jobs when they moved the facility to Newport, Rhode Island. It left behind 32 acres that the government said must be developed in a commercial manner, according to the BRAC statutes. These 32 acres was on Fort Trumbull Peninsula. Fort Trumbull Peninsula was 90 acres, so a third of it was to be developed commercially. That was the bad news for New London. The good news, 2 years later, Pfizer announced that it would be constructing its global research headquarters on land off Fort Trumbull, this parcel here that was a linoleum factory. We have EB to thank for building that piece of property because it was really water. Until they needed to dredge for some submarines across the river, they dumped it all there with 3 skeletal PT boats from World War II. That's why the Pfizer project, when it was done, was built entirely on pilings, So that was the good news that Pfizer was coming to New London, they had three demands of the state of Connecticut. One, remove a junkyard, Calamari's junkyard, right there. They wanted it removed. We have on Fort Trumbull a regional sewer plant. We take sewer all the way from Old Lyme into New London and process it. Contains 2 full blocks. They wanted that regional sewer brought up to state-of-the-art facility. If you see these sewer plants, they usually have a big bubble on it. New London didn't have a big bubble. We couldn't afford it. It was open, and it smelled. Pfizer said, bring it up to state-of-the-art. State of Connecticut said yes. And Pfizer wanted the fort in Fort Trumbull, which, by the way, in this photograph here, which one do I have up here? I think I went to the other photograph. This fort here, if we can just give me a moment, you can see the fort there in that picture, but if we go to here, you can't see that fort. I grew up in New London. You couldn't see that fort from the water or from land because the Sound Lab had buildings all around it. Pfizer said renovate that 1840 fort, and the state of Connecticut agreed. Now, after Pfizer arrived, the state of Connecticut made an offer to the city of New London. Since the state was already spending $20 million to refurbish that Fort Trumbull as a state park, and spending millions to upgrade the sewer plant, the state said to the city of New London, do you want $70 million to improve the roads, infrastructure, and land between that Pfizer site and the downtown New London area? Do you want the money to clean up the environmental issues of the Fort Trumbull property? It housed not only the junkyard, a railroad stockyard, oil storage terminals, car repair businesses, manufacturing business. Do you want money to fill the floodplain? Because in every rainstorm, that area flooded. Only 2 ways to get into Fort Trumbull: under a railroad bridge. Any significant rainfall, it was flooded. Couldn't get in, couldn't get out. Do you want the money to rebuild the roads, the sidewalks, the sewers? Do you want to create public access to the Thames River, which never existed before? And New London did not have $70 million in its fund balance. Now, the answer was either no. Thank you, state of Connecticut. Keep your $70 million. We'll pass on this offer. We'll let the New London taxpayers clean up the brownfield sites. We'll let the New London taxpayers do the roads, fix the sewers. The lines were 100 years old at that time. We'll let the money go to New Haven, Waterbury, Hartford. They seem to be getting all the money from the state, so we'll pass on it. Well, New London said yes. And let me tell you why New London said yes. New London is the second smallest in size of the state's 169 cities and towns, the sixth most densely populated. As of 1997, only 11 of its approximately 4,000 acres was undeveloped. 56% of the land was tax exempt. Think about that. You have to rely on your real estate tax base, and 56% of your land is tax exempt. That's because the city is home to 3 colleges, a regional hospital, churches, many, many nonprofits, and of course the 6 lanes, including frontage roads of Interstate 95, go through New London. Unemployment was about double the state average, and New London had been suffering a declining population for the past 20 years. There were almost non-existent housing starts. And the taxpayers were taking budget after budget after budget to referendum. They weren't spending any more money. Where was New London to get more money? So that's why New London said yes. That's what they were facing in 1999 when the state offered $70 million. Now let's look at this area. Let's look. This is the before construction site of the Fort Trumbull area. It is a peninsula on the Thames River. Only 2 entrances, as I mentioned, under the railroad tracks to this area. It was known as the fort This area has been zoned commercial and industrial since 1929. When I give this fact out to people, they're amazed that the plan of development for New London, for this area, since 1929, I think that's when the United States Supreme Court decided Euclid versus Ohio, the first zoning case. Well, New London adopted zoning in 1929. And from 1929 to the present time, New London said the plan for this area of town is commercial and industrial. So by the mid-1990s, the Fort Trumbull Peninsula had an 80% commercial vacancy rate. That's in a commercial zone. 80% commercial vacancy rate. It had a 20% residential vacancy rate. So most of the structures were built before the turn of the previous century. 88% of the properties were in fair to poor condition. Only 12% of the properties were considered average. This is the area that New London decided to invest $70 million in, offered by the state. This was no residential zone. This was no Victorian landscape. This was a much neglected, largely abandoned section of New London. So these were the circumstances that confronted my client in the late 1990s when it considered its municipal development plan. Now, the state decided to proceed under 132, economic development, and go with a non-profit entity. So the basis of the takings was economic development and not blight. We won't go into that decision. I wasn't privy to it. But that said, one of my favorite quotes of all the cases that commented and all the commentary on KELO is Judge Corradino's from his 249-page trial court decision. In a footnote, he said, on the issue of whether economic development could be a basis for a taking under the Constitution, he said the following, quote, "The bleak economic conditions that earned the city of New London the designation of a distressed municipality are conditions just as worthy of attention and dangerous to the economic and moral health of the state as slum and blight areas." Now, as an advocate for the MVP, as an advocate for the city of New London, along with NLDC, we presented to the trial court the bleak outlook for the city of New London, its struggles, its inabilities to provide basic services to residents, and New London was at a crossroads in its 350-year history. When you think about it, how often does a state come and offer you $70 million? How often does a major pharmaceutical company of international renown decide to build within your borders? And how often does a military base close and offer you 32 acres of commercial land? This all came together in the late 1990s. So my client accepted the $70 million, and I like to say we put the $70 million basically into the ground. We transformed the landscape of this entire area. And as I stand here today, I can say that New London and its taxpayers achieved all of the public benefits from that plan. The Fort Trumbull Peninsula has been remediated of its brownfield soils. The floodplain has been filled. There's no more flooding with every major rainfall. The area has rebuilt sidewalks, sewers, water lines. 3.5 miles of electrical conduits were replaced. 1.5 miles of drainage pipes replaced. 1 mile of water mains replaced. 125 streetlights. 34 catch basins that used to take the groundwater and dump it direct into the Thames River are gone, replaced with 6 catch basins that now treat the water before dumping it into the Thames River. We enjoy the complete restoration of Fort Trumbull, the improvements to the sewer treatment facility. We have public access to the Thames River. We have a public walk along the 90 acres all along the Thames River. Those are the benefits. And yes, The city has more in taxes today than it did at the start of the MDP. Not much, but in 2000, the tax revenues collected were approximately $250,000. In 2014, it was $471,400. You'll hear the criticism, but there's nothing going on down there. Well, the one building that the BRAC left us is fairly full, and they're all paying taxes on it. But while it's been 10 years since the Supreme Court decision, we haven't had 10 years to market it. It took a couple of years to negotiate the buyout with the people who would not leave, even after the Supreme Court decision. And then it took another couple of years to integrate those properties into the landscape. So we really haven't been at it in 10 years, but we have achieved all of the public benefits because the money went into the ground, and this plan had substantial and significant public benefits. And just like the Blight statute, at the end of the process, you have paths for development, and that's what New London has now. For me, it's very frustrating to read Justice Scalia when he lumps this case with the Dred Scott decision, and he lumps this case with Roe v. Wade, and that Justice Sandra O'Connell writes, "The specter of condemnation hangs over all property." Wow, or the current mayor of New London. He wants to wash clean the stain in our city. Well, my reading of the majority decision of the United States Supreme Court leads to no such conclusion. To me, the United States Supreme Court said, "We emphasize that our decision is not a license for the unchecked use of the eminent domain power as a tax revenue raising measure. And it has long been accepted that the sovereign may not take property of A and give it to B solely for the purpose of transferring it to a private party, even if he's paid just compensation." And Justice Kennedy, "Transfers intended to confer benefits on particular private entities and with only incidental or pretextual public benefits are forbidden by the public use." Incidental or pretextual public benefits. New London had far different situation. We had substantial and significant public benefits, which I've just alluded to. So the inescapable conclusion from the majority opinion and the concurring opinion is that municipalities cannot take property from A and give it to B solely for economic reasons. You have to have substantial and significant public benefits which were in the plan, which were in the plan that we had. Now, I often give this example. The bridge between economic development and the public use doctrine is a bridge filled with public benefits and public uses. If the only vehicle you have on that bridge is economic development, more taxes, if that's the only vehicle, I think your plan's going to be in trouble after my reading of the United States Supreme Court. You need vehicles on that bridge that have significant and substantial public uses and public benefits. Certainly, over the last couple of years, the worst economic decline since the Depression has made development more difficult. Hopefully, with the loosening of the credit market and better economic conditions, the last goal, even though it's been slightly increased in tax revenues, the growth in the grand list will be achieved. I have no problem with the decision my city made, facing the facts and the events at the time. The plan was good for the taxpayers of New London. I was honored to be representing the city in this case, and I would do it again because I believe in the principles of what urban America is trying to do. Now, I laugh to myself, of course, when I read in the paper that a town around New London is passing a local ordinance, that they are going to pass an ordinance that's going to forbid that town from taking property for economic development by the use of eminent domain. I say, good. I don't think you should have it. I think the power of eminent domain is for cities and urban centers that have the social responsibilities that I alluded to. They need the power of eminent domain. So let me conclude with a few. How much time do I have? I'm done? I'm done. I'm done. I'll conclude later.
Like the end of your argument, right?
Tom, I know what you feel like.
Yes.
Good morning. As Bethany explained, I'm here in lieu of Scott Bullock, who actually argued the KELO case in the U.S. Supreme Court. I was on the trial team, so I know all the players. I'm good friends with Suzette and Michael Cristofaro, who's with us in the audience, and all the other clients. So I know what happened in the case, and I have maybe some ways the benefit of having been able to observe the unfolding of the case, not in a completely objective manner, but I wasn't working on the case day to day as my colleague Scott Bullock was, but I was there for all of the important events, including the trial, which I participated in, and the Supreme Court argument. So, listening to Tom's talk, I am reminded of a quip about the Vietnam War that for many people came to distill America's experience of that war, and it was apparently an American military officer was explaining why we leveled an entire village in the Mekong Delta, and he said, well, in order to save the village, it became necessary to destroy it. And I think it's really fitting that the image in front of you is a satellite image in which you can't see any detail. You certainly can't see the details and the features of the homes that were bulldozed, the faces of the people who lived in those homes. For the city, this case was always about a development project, a development plan, a development site, never about homes and the people who owned those homes, the people who lived in those homes. I want to tell you about one of those people, someone you probably haven't heard of, not Suzette KELO. I want to tell you about Wilhelmina Derry, who was an old woman living in Fort Trumbull at the time that the eminent domain project was proposed. She was born in the home that New London proposed to bulldoze in 1918. She never lived anywhere else. She spent her wedding night in that home. She raised her children in that home. Every holiday, every Christmas, every warm memory of her life was in that home. And they didn't ask her if she wanted to sell it and move because they knew the answer. The answer was no. Instead, they told her, you are leaving. You're not welcome. You won't fit in with this project. Imagine saying that to an 85-year-old woman in a home that's the only place she's ever known. It's not a house. It's not a site. It's not a lot. It's a home. And the Constitution is not esoteric. There's nothing esoteric about the protections of the Constitution. They're there for individuals. They are there for everybody in this room. They were not esoteric in Gideon v. Wainwright, when a man said he had a right not to be sent to prison if he didn't have representation in his criminal trial. And that leads me to, I think, the most important point I can leave you with, and that is this. Just because the Supreme Court says a thing is okay doesn't make it so. I'm a constitutional lawyer. Let me give you some examples to illustrate this point. In 1873, in a case called Bradwell v. Illinois, the United States Supreme Court said it's perfectly fine for the government of the state of Illinois to forbid women from practicing law on the premise that they should be home having children and because women become too emotional in the presence of a judge and they're incapable of logical thought required to practice law. Was the Supreme Court right about that? I think not. In 1896, the U.S. Supreme Court said it was appropriate, or at least constitutionally legitimate, for the government, the state of Louisiana, to require that the races be in separate train cars. In 1927, the U.S. Supreme Court said that the state of Virginia could use compulsory eugenic sterilization to sever the fallopian tubes of a 19-year-old woman named Carrie Buck. And there followed 60,000 eugenic sterilizations over the course of the 20th century because the Supreme Court said the Constitution permitted it. In 1944, the Constitution said that it was permissible under the Constitution to lock people up in concentration camps here in America, not because they were suspected of any crime, but because of their heritage, specifically because they were Japanese Americans. My wife is half Japanese. Her relatives died in those camps, and the Supreme Court said it was constitutionally permissible. And in 1986, the U.S. Supreme Court said it was permissible to put people in jail for having gay sex, a decision that was reversed less than 20 years later in Lawrence v. Texas. So let us dispense with the thought that because the Supreme Court says a thing is constitutionally permissible, it is morally proper. And I would say that those cases have one thing in common, by the way. All of those cases authorize the government to engage in conduct that is now considered so far beyond the moral pale that you don't even need a Supreme Court ruling to prevent it, because no one would do it. And I would say that to those cases, one will be added, and that is KELO versus City of New London. The Supreme Court may or may not reverse itself on that decision. There have been a number of justices who said they hope they have an opportunity to reverse it. I hope so too. But I'm not sure it'll be necessary. Because in some ways, the story of the KELO case is a story about how the City of New London took an obscure 13-word term, eminent domain, and turned it into a 4-letter word. I regularly fly around the country doing different speaking engagements, and I talk to people, and I'm amazed. Before the KELO case, no one had ever heard of the term eminent domain. It was an esoteric and obscure term. Everybody knows the term eminent domain now, and virtually everybody has the same opinion about eminent domain. That, in some ways, is the legacy of this case. I'm going to start with the aftermath of the case, because I think it's important to first understand how people feel about this case, and then I'll work through the decision, which I obviously disagree with, and then I'll tell you a bit about how the case unfolded from the perspective of the people whose homes were taken, and in some cases, bulldozed. In fact, in every case, bulldozed, with one exception, which I'll get to at the end. The reaction of the public to the KELO case was swift and virtually unanimous. It is the most reviled Supreme Court decision in living memory, I think for good reason. It was immediately condemned in the media. It was condemned in the Senate of the United States. The House of Representatives passed a resolution condemning the KELO case. The Senate held hearings within 3 months to condemn the KELO case. 80 to 90% of people polled say that they disagree with the case, but they disagree strongly with the Supreme Court's decision. 47 states would either amend their state constitutions or enact statutes to make eminent domain for economic development either impossible or substantially more difficult. And with the exception of the state of New York, every single state Supreme Court to consider the issues presented in KELO under their state constitutions have emphatically rejected the Supreme Court's reasoning. It is fair to say that in the history of the United States, it has never been more difficult to use eminent domain for economic development than it is today, notwithstanding a U.S. Supreme Court decision that says it's perfectly fine. That is the legacy of the KELO decision in many ways. I want to talk briefly about Justice Stevens' opinion, because I think it's not only wrong, it's obviously wrong. And I'll introduce my first point let me give you the 3 reasons why I think it's wrong. First, I think it's un-American. Second, it essentially deleted the public use provision from the Fifth Amendment, something that Supreme Court justices are not authorized to do, delete text from the Constitution. And third, it reflects an extraordinarily naive view of the way in which policy of this kind is made. Let me start with the first point. In September of 2005, about 3 months after the KELO decision came down, I was at my alma mater, the University of Texas Law School, to debate the KELO decision with a property professor there. And I had some time before the debate, and I noticed that a couple of partners from the firm that I used to work at in Dallas were down at UT Law School recruiting, and so I went up to say hello. They were both friends of mine. And I told them what I was there to do, and one of them said, "Hey, I have a story for you that you might find interesting in relation to the talk that you're about to give." He said, he was an intellectual property partner. He doesn't know anything about the Constitution. Well, I don't know that for a fact, but he's not an expert in constitutional law. And he said, I was just over in China in May. So that was 1 month before the KELO decision came down. And he had no awareness of the case, but he happened to be in China a month before KELO came down. And he said, I was there to work on a computer chip factory for a client here in America. They were going to help, they were going to participate in the construction of this computer chip factory in China. And I was there to help finalize the deal. And on the last day of my trip, my host said, "Hey, would you like to go and see where the factory is going to be?" And I said, "Sure." And so the two of them drive out in the countryside, and they come up over the top of a hill. The host parks the car, they get out, and he gestures down at the bottom of the hill, and there's a little village there, and he says, "That's where the factory's going to be." And this friend of mine, the partner at the firm, said, "Well, we can't put a factory there, there's a village." And he said, "Oh, the government will make them leave." And without even thinking about it, this American lawyer said, "Oh, well, you can't do that in my country." 1 month later, we found out he was wrong. I think what he was expressing was not some reflective opinion about constitutional law. As I said, he wasn't an expert. What he was expressing was his conviction as an American citizen that if you lawfully own a home or a small business, the government can't take it from you unless they really, really need it for some truly public use, like building a highway. But they don't get to take your home or your business simply because you're not using it to its highest economic benefit. Is anybody in this room using their home or small business to its highest economic benefit? I doubt it. And that was Justice O'Connor's point in her KELO dissent, that the specter of eminent domain hangs over every home and small business in America. And that's absolutely true, because virtually every plot of land in this country could be put to a higher economic use, and if that's all that matters, if that's all that's necessary, and it is, then the specter of eminent domain really does hang over every home and small business, and people don't like that. People, understandably, feel that they are in jeopardy if they don't have the political muscle to go in and take on the lobbyists from Corcoran Jennison or some other large property developer. You should be concerned. We've represented eminent domain victims from one side of this country to the other, and you know what? Justice O'Connor was correct about another thing. Eminent domain the effects of eminent domain are not random. People like you don't have your homes taken. You know whose homes are taken? Working class people. People who had the foresight to buy a bungalow in Long Beach, New Jersey, an actual case that we worked on, in the 1960s when no one wanted to live there. And suddenly it's a very attractive place to be because it's right on the ocean. That's who loses their homes to eminent domain, not people like you and me. I won't belabor the point about Justice Stevens deleting the public use provision from the Fifth Amendment. It was put in the Fifth Amendment to stop exactly this. And there's all different ways you can dress up. I mean, nobody actually shows up and says, hey, we're going to take your home and give it to that guy because he's more rich. Nobody says that. But that's the effect of this decision. And really, it came down to, it was teed up by Justice O'Connor in one of the most famous exchanges in the whole case, when she asked Wes, who will talk about this, I'm sure, during his talk, under your theory of eminent domain, could a government just take a Motel 6 and give it to a Ritz-Carlton just because they're going to build a nicer hotel? And he said, and to his credit, he said honestly, yes, that is our theory. But it didn't need to be a hypothetical, because that really wasn't the issue in KELO. I mean, in some abstract constitutional sense it was, but it didn't need to be a hypothetical. You could have asked that question without a hypothetical. You could have said, under your theory of this case, can the government take a $53,000 bungalow belonging to a working class nurse and give it to a property developer just to put up a $600,000 townhome for a Pfizer executive? And the answer would be the same, yes. And that's wrong. The Supreme Court said it was constitutional, but it's still wrong. The last point I want to make about the Justice Stevens decision is how incredibly naive it is about the way the politics of eminent domain works. If you read Justice Stevens' opinion, you get the impression that on the night before they authorized eminent domain, the New London City Council, the individual members lay awake in bed in a cold sweat, tossing and turning as they tried to balance the interests at stake, Suzette Kelo's house, Wilhelmina Derry's house on the one hand, and the desire to raise tax revenue and revitalize the city of New London. They wrestled with this question into the wee hours of the night. No. This project happened exactly the way you think projects like this happen, in back rooms and executive suites. The public didn't have an iota of participation until the train had left the station. That's the way this project was planned, and that's wrong. And if Justice Stevens suggests otherwise in his opinion, and he does, he's wrong. It's not how eminent domain works. It's not how projects like this are planned. There's no late nights. There's no cold sweat. There is fear of political accountability, I will say that. But there was no wrestling with consciences. As soon as the state came with its bag of money, and Pfizer came with its list of requirements for what it wanted in the eminent domain area, which you see here, the deal was done. All that remained was the details and the PowerPoint presentations. Now I'll get to the backstory. I only have a few minutes, and I don't need to tell you very much about it, other than one important point that's, I think, the key to this whole thing. If the city of New London had come into the Fort Trumbull neighborhood and explained what they wanted to accomplish, and come with open hands and an open mind, and said, what can we do together to achieve the goals that we have for this neighborhood, the outcome of this case would have been much different. But they didn't come that way. The way the residents of Fort Trumbull knew that something was up was suddenly real estate agents were coming to people's doors and calling them on the phone, asking if they wanted to sell their homes. Some people did. In fact, some people got very good payments, very good offers on their homes, and left happily. The problem was that the people who didn't want to leave, and there were some who just didn't want to leave, the conversation didn't end there. These real estate agents at first were a little bit coy, but they suggested that maybe it would be a bad decision to say no to me. You might not have so many opportunities to say no. Something could happen. It's a nice house you got there. It'd be a shame to see something happen to it. And what slowly became clear to the owners who didn't want to leave in Fort Trumbull is that they weren't being asked. They weren't being invited to participate in an economic development plan. They were being threatened, not with a gun, but with a bulldozer. And one of the things I think that they most resent, although I can't speak for them because this didn't happen to me, I only represented them, but I think that one of the things they most resent was the lack of candor in the way this went down. They were threatened with eminent domain, but then when they went to the New London City Council to ask if that was really on the table, they couldn't get a straight answer at first. Well, we hope it doesn't come to that. Well, we haven't authorized that yet, et cetera, et cetera. So they're being threatened on the one hand, but no one will step up and take political accountability, at least at first, and admit that, in fact, that is precisely the dynamic. You are not being asked whether you wish to sell your home. You are being told that you will leave your home, and the only question is how much money you'll get. But you're not staying. Basically, the City of New London had two words for these property owners: get out. I'll finish with this. I mentioned at the beginning of the talk that all of the homes in this neighborhood were bulldozed with the exception of one. That home is Suzette Kelo's, the little pink house that became iconic in this case. That home wasn't bulldozed because instead it was disassembled. It was lovingly disassembled and reassembled on a plot of land that was donated a couple of blocks from the courthouse where the trial, the state court trial in this case, occurred. And this is what I want to leave you with. The key disagreement, I think, between my group, the Institute for Justice, and our clients on the one hand, and the City of New London and its lawyers on the other was, did it have to come to this? Was this really necessary, regardless of what the Supreme Court said? Obviously, I think the answer is no, and here's why. As I said a moment ago, if they had come into Fort Trumbull with open hands and an open mind and no bulldozers, most of the people would have left. The offers were generous. The offers were reasonable. Most of the people were willing to sell. The question was what to do with the people who didn't want to sell. And the city made its biggest mistake when it threatened them, when it put their backs up against the wall and said, you will leave. That's when they decided to dig in and fight. And I'm here to tell you, it didn't have to come to that. And you know how we know? Well, one of the reasons we know is that what happened to Suzette Kelo's house is what she proposed should happen all along, right from the beginning. Let's move it to somewhere else. And I'm here to tell you that that house didn't even need to be moved. It could have been worked into this plan. We brought in one of the most respected urban planners on the Eastern Seaboard, John Mullen, and he testified that the few remaining homes could have been incorporated into the design plan. And he also testified that in his experience, and he has years, decades of experience, he wasn't familiar with he'd only ever seen one project, one redevelopment project that had ever involved the total clearance of a neighborhood. Usually it doesn't involve that. Some properties remain. So do this. Instead of taking my word for it, go down to New London, go find Suzette Kelo's house a couple of blocks from the court. It's beautiful. And ask yourself this question. Did that house have to be torn down? Could Suzette Kelo have stayed in that neighborhood? Could everybody have gotten along? And the answer is absolutely. Thank you.
Good job.
I'm going to slink up to the podium. The reason I wore all maroon today is it's the same color as rotten tomatoes. So I thought I ought to be prepared in case I needed that. I came into the case in early 2004 when the case was before the Connecticut Supreme Court. In early 2004, the Connecticut Supreme Court unanimously, all 7 justices, said this was a taking for a public use. There was a 4-3 decision, however, on whether there should be a heightened test for economic development takings, with Justice Zarella, who is sitting in the back writing the dissenting opinion, saying, yes, it's a public use, but it has to be a higher test. And this was under the United States Constitution. There was no decision concerning the Connecticut Constitution because the issue hadn't been raised by the plaintiffs on the subject and in the Connecticut Supreme Court. I was then told that the Institute was going to file a petition for certiorari to the United States Supreme Court, and the defendants hired me to defend it. And their petition came in over the summer of 2004, and it did not adopt Justice Zarella's dissenting opinion because that would have required them to say that it was a public use. Rather, they went shooting the moon to say this is not a public use at all. I thought that they had no chance at all of having the petition for certiorari granted because there was no conflict among the cases on that subject. There were 2 United States Supreme Court decisions that were unanimous, one from the District of Columbia, one from Hawaii, one of them, the one from Hawaii having been written by Justice O'Connor. And there was no really dissent among state Supreme Courts on what federal constitutional law was. Later that summer, there was a decision from the Michigan Supreme Court saying that economic development was an improper basis for exercising eminent domain under the Michigan Constitution. But that didn't have anything to do with federal law. So I was quite shocked when the U.S. Supreme Court in September granted the petition for certiorari. Now, there were a number of land use planning professors and others who thought, in light of the cases out there from the United States Supreme Court, that I surely was going to win. In fact, it might be 8-1 with only Justice Thomas dissenting. But that wasn't my view, because if that were so, why did the petition for certiorari get granted? And also, I knew that the reversal rate for petitions for certiorari granted is 70%, 7-0. When you get the petition for certiorari granted, that's a time to celebrate because you're likely to win. And the only exception is if you can get the federal government on your side as the appellee, then the rate goes down to 50%. But I knew I had a serious problem there. And so we waited for we were trying to get the federal government involved on our side, and they were not making up their mind. In late 2004, the plaintiffs, the Institute for Justice, filed their brief, and it was consistent with what we had expected. They did not make any serious effort to get the Supreme Court to adopt Justice Zarella's dissenting opinion. They simply wanted to say that economic development is not a proper basis for exercising condemnation rights. That actually made our decision for writing our brief easier in one respect, because think about it. If we had to deal with Justice Zarella's dissent, then the fact that the city had developed the plan and hadn't put it out to developers left us vulnerable to Justice Zarella's point, which was that's a field of dreams. It's all speculative. You don't know that it's actually going to work. And that allowed us to focus on the fact that it was not developer-driven, and therefore it was actually a matter of public interest. It was prepared by the city itself and not by some developer making a profit on the matter. And for the reasons that Tom Londrigan mentioned, it really was in the public interest, not some private interest to do it. So we didn't have this catch-22 situation that if we talk about focus on how much the city was involved in it, we make ourselves vulnerable to Justice Zarella's dissent. So we ended up, therefore, writing a brief that was very fact-oriented. The brief was written by my partner, Dan Krish. I'm sorry he's not here today, but he had to go to a court proceeding and it was very interesting. He and I discussed it in great detail. This is not a case to discuss legal theory. It's a case to talk about the facts. Now, there's some irony here, because when you go to appellate conferences, the people who are speaking, judges included, always say 75 or 80% of the case is decided on the briefs. The oral argument, may make a difference 10 or 15% of the time, but the briefs are what appeals are about. The irony is, since the KELO case has been decided, I haven't heard one scholarly discussion of our brief, or anybody's briefs. And everybody likes to dissect my oral argument, which is fine, except it's very, very interesting that way. The briefs may be great in deciding the case, but nobody pays attention to the briefs afterwards, and everybody pays attention to the transcript. So I will talk about the transcript. So in preparing for oral argument, I ended up having 4 mooting sessions where other lawyers or professors play Supreme Court justices and pelt me with questions. I had 2 of them at my office. I had 1 of them here. And I had one of them at Georgetown, where they have a room that replicates the Supreme Court. And when I was here, one question that was asked was, ironically enough, precisely, I don't know what Motel 6, is there something about Motel 6 that gives everybody the idea it's a crummy hotel? I mean, that appears to be it. And the Ritz-Carlton is the best. So the question came out, the precise question came out, can you condemn a Motel 6 and give it to a Ritz-Carlton? I said no, that's going too far. And when I was here, the professors thought that was the correct answer, and everything went great. Then I went down to Georgetown. And I got the same question with the same hotels, and it was a disaster. Because as soon as I say, no, that's going too far, then I spent the 15 minutes arguing with the professors about where to draw the line. Well, how about 2 Motel 6s? And, how about this? There were every hypothetical, and I was in trouble. So I decided, well, what is the honest answer to that question? There's only 3 possibilities. One is yes, the second is no, and the third, Your Honor, that's an irrelevant question. Now, the correct answer is the third. It's an irrelevant question in this case because it didn't matter. We were nowhere near any line along, assuming that economic development was proper under any circumstances. We were so far from the line that it didn't make any difference. But you don't need to take an appellate advocacy class to know you cannot tell any judge that's an irrelevant question, Your Honor. So it was either yes, no, or I don't know, Your Honor. And you can't say I don't know. So I had yes or no as the answer. If I said no, Your Honor, I knew what was going to happen. Justice Scalia was going to pop up. And Justice Scalia doesn't ask the longest questions, but he does ask the most questions. And I just knew that he would have fun with me for 10 minutes, wasting my time on where the line was. So I decided to take a deep breath, and if the question comes up, I'm going to say, yes, Your Honor, because that stops the questions. You've taken the most extreme position. There's nothing further they can ask on the subject. And then I wait for somebody to ask me a question about the facts of the case. And then I can talk about, I don't have to say, and that answer I gave is irrelevant, but look at the facts of the case. We're nowhere near the line here. So that's how I decided strategically I was going to handle the case if the question came up. So what happened? And also, because I wasn't as optimistic as many professors who do this, I was thinking this way. I have to assume that I've got the 4 liberal justices, Stevens, Souter, Breyer, and Ginsburg, on my side, because if I lose any one of them, I've lost the case. And I have to assume that I don't need to pay any attention to Justice Thomas, because he's not going to ask any questions anyway. And I have to assume that Scalia and Chief Justice Rehnquist, Chief Justice Rehnquist was very sick at that time and not likely to be there anyway. But Justice Scalia, I'll answer his questions quickly, but he's not He's not going to be my fifth vote. My fifth vote is either going to be Justice O'Connor or Justice Kennedy, and the two of them are very fact-oriented. And I figured my fifth vote was more likely than not to be Justice O'Connor. Brilliant analysis I had made of the situation. But they're both very fact-oriented. They're not extremists, not black and white people in terms of legal issues. So I figured a factual orientation was best, and I was hoping that one of them was asked the question. The interesting thing is that Justice Stevens missed his flight that morning. It was the first day of the session, and so Justice O'Connor at the last minute was presiding, and nobody knew what she was like. It was interesting, the first time a woman presided in the U.S. Supreme Court. And so nobody knew what she was going to be like. So I'm cruising along with my argument, and Justice O'Connor, for example, Motel 6, and the city thinks, well, if we had a Ritz-Carlton, we would have higher taxes. Now, is that okay? Mr. Horton, yes, Your Honor. Playing right into the Institute for Justice's hands in terms of their publicity machine, which is magnificent. But that was the answer I had to give if I wanted to get off, and there were no more questions to be asked on that. And so 3 pages later, Justice O'Connor says, so what are these parcels of the people now before us going to be used for? Thank you, Justice O'Connor. Just so happens I have a chart to show you. And so there's a much better person who has talked about this than me, and it's Dahlia Lithwick, who was there, and she's a reporter. I've witnessed some weird moments, oral argument over the years, but I'm thinking absolutely nothing could compare with the sight I beheld today. In the midst of argument in KELO versus New London, the lawyer for the city of New London, Connecticut, pulls out an actual prop in response to a query from Sandra Day O'Connor as to whether there's a concrete development plan for what would replace the handful of homes being condemned. Wesley W. Horton hauls out a big poster board with the whole proposed community laid out. Condos here, marina here, yank out this crappy little Victorian house, and the health club will go there, he enthuses. My heart begins to pound. I want in on this deal, and O'Connor looks like she does too. With the exception of a yellow pad, I have never seen a visual aid of any sort used at oral argument. Advocates really should use them more. So I was pleased with the editorial the next day. It turned out it was the person that I was convincing, if I was convincing anybody, sure wasn't her. But it may have been Justice Kennedy, because he did turn out to be the fifth vote. At the end of the argument, you have lights, and at the red light you have to stop, even mid-sentence. At least that's the rule. And the red light may be coming. Oh no, don't! It's a yellow light. Yeah, I'm very familiar with red lights. So we get to what I think is 29 minutes, because I'm the appellee, so I have to put all my argument in once. And so it seems to me the 4 words I think that this court should consider, ... And I'm not going to tell you the 4 words since my red light is on. Thank you, Your Honors. Justice O'Connor, Mr. Bullock, you have 3.5 minutes. Justice Kennedy, Mr. Bullock, do you know what the 4 words were? So they all had to read the paper the next day because, of course, the first thing that happened when I got outside the Supreme Court was the Washington Post asked me what the 4 words are, and they blasted them all over the news reporter the next day. And so I'm sure they all found out what the 4 words were. And the 4 words are precedent, federalism, compensation, and democracy. And I think those are the 4 words that do capsulize our case. The precedent, we had the cases on our side. Federalism, and this is for the more conservative justices, is why do you want to sweep all the, everybody in the United States under one set of rules? The whole idea of federalism is you have experiments with various states. One state says it's unconstitutional, another constitution, and another says it isn't. But if the KELO plaintiffs had won, all the state constitutions would be irrelevant. Compensation, the point is everybody gets paid here. Inverse condemnation, or what I call over-regulation. Over-regulation, it doesn't reach the level of inverse condemnation, is something where there's no compensation at all. And the fourth thing is democracy, which is if there's an agreement by the city council or others to condemn property that becomes unpopular, they're going to be voted out of office at the next election, and they're going to be thinking about that when it goes on. So so those were the 4 words, and the decision then comes out. It's a 5-4 decision. Justice O'Connor's dissent is the one that's mostly talked about, but Justice Thomas's dissent is actually very interesting for himself. Talking about basically sweeping away all the old cases and, examining what was going on back in the 1890s and then attacking that, which is something Justice O'Connor did not do, because she basically said her dissent was consistent with the case she had ruled on earlier and another case from the District of Columbia. The majority opinion has 5 votes. Interestingly enough, Justice Kennedy voted as the 5th vote for the majority opinion by Justice Stevens. But then he wrote his own concurring opinion, which was very fact-oriented, which talked about the things that I was talking about when I was holding up my chart here, showing that there was no question in the case that this was a well-planned thing, not just one piece of property or something. And he goes into detail about the sorts of things that might lead the courts to invalidate plans that aren't in existence here. So when people have asked me, for advice on whose opinion should you be following if you're the town and want to do something, while nobody else voted for Justice Kennedy's opinion, he was the 5th vote, and my opinion is that his is the opinion that should be watched. Thank you.
So everybody did an amazing job keeping within time, and we've got 20 minutes for questions. And while we're teeing up our first questions, I want to say that often we look at U.S. Supreme Court cases and think, oh, they're so long. But in this case, actually, the trial court and the Connecticut Supreme Court opinions were about 4 times longer than the U.S. Supreme Court opinion. And it was because neither the trial court nor the Connecticut Supreme Court, after some discussion, had problems with the public use requirement, public use requirement, but all of them felt like, okay, what does that mean? What is the possible higher standard that we might want to apply in those cases? What do we have to show that this will really happen? So I think the Connecticut courts who are a lot more creative than the U.S. Supreme Court.
I agree with that, yeah.
Hi, this is a question for Wes. I'm Sarah Porras, and while I was a student at UConn, I interned at the Center for Children's Advocacy. So I know you, Wes, from working on the Sheff versus O'Neill matter.
Hi, yeah.
So I was really surprised because I perceived you as an appellate advocate for the white hat wearing side, and so I didn't see you necessarily. It didn't go with who I knew you to be to represent the city. Can you talk about that a little bit?
Okay, let me say,
You're the white hat.
I disagree with your view that I have the black hat here. And let me tell you why. And it's relevant to Sheff versus O'Neill, which is the school desegregation case that was mentioned. My view is that this is actually, that the majority opinion is good for a minority people in general. The reason is that if you can't take property for economic development, then then the city, a place like New London, is far more likely to be looking around to find substandard housing, that's something that they can condemn under traditional rules, and where are these more slum-like properties going to be? They're going to be in minority neighborhoods. So you're going to have a place, you know, especially larger cities, that they're going to be condemning property if they can't use economic development, which can be in middle class or upper class areas. It doesn't make any difference where it is, but you know, if you can't use economic development to redevelop, and you want to redevelop, then you go with the areas of town where you have a traditional right on the basis of public safety to condemn properties, and that means minority neighborhoods. So I believe that I have the white hat.
He does.
My name is Morton Katz. I'm a simple company lawyer from Avon. And I have a question for Tom Landrigan, the city attorney. To what extent have the promises of economic development have been fulfilled as a result of all this?
To the extent that we are receiving more taxes from that area now than we did at the time of the taking. As I mentioned in my talk, it is not that significant, but we haven't been at development for that long. The decision was 10 years ago, but it took a couple of years to acquire the properties by settlement negotiations, and then it took another couple of years. So there was approval for a development, but the developer backed out of it. But we were told from the very beginning that it's a 20-year plan, that the municipal development plan is not going to happen overnight, that it is going to take about 20 years to fully develop it. Having the worst recession since the Great Depression certainly hasn't helped in the last few years. But I think there is progress, and there will be development.
Just to follow up then, have you had any hint or a heads up on prices pulling out?
None, other than the fact they stayed for the full 10 years of their tax abatement, which the state of Connecticut gave them, and in 10 years in 1 day they left.
Hi, my name is Algus. I work in architecture and engineering, and I often work with energy companies, pipeline companies specifically, and I'm wondering what kind of effect has the decision had on American energy, specifically pipelines? Sorry for the broad question, you may not know, but I'm wondering if it's had any effect on the way that the pipeline industry sort of takes properties in order to establish their goals.
Why don't you handle that question?
I mean, I think we've got more of an expert than me. Mr. Domino, I think, is going to probably address that in another panel. What I will say is my understanding is that the use of eminent domain for things like constructing energy pipelines or privately owned railroads has been approved for a long time. It really wasn't the issue in this case. There are other defenses, there are other legal issues you can raise, but I don't think the public use issue that was the heart of the legal dispute in this case really is intrinsic to those cases. I don't think that's really what those cases focus on, but I hope that Mr. Domino will correct me if I'm mistaken about that, but he's worked on those cases and I have not.
And we're so pleased that David Domino is speaking this afternoon on his work regarding takings for the Keystone Pipeline. And I want to invite you to make a remark now if you wanted to. He's going to wait. Humble lawyer. What? Yeah, so you got to come back for it.
Yes, hi, this is for Mr. Landrigan. I think I heard you say that, that some municipalities should have the power of eminent domain for economic development, some shouldn't. I just wonder what the specific test is that you would propose for that.
Well, the first test I would have would be a distressed municipality. If the state of Connecticut has designated you a distressed municipality, you have to do something to turn that around. I would draw the line right there. I see this as a conflict, as I mentioned, between suburbia and the urban centers of our state, or the urban centers of our nation. So if you fit the criteria for a distressed municipality, declining population, unemployment, and all those issues that the state statute has, I don't have a problem limiting the power of eminent domain to distressed municipalities. I'm not sure. One of the surprising things to me were the support we got from environmentalists filing amicus curiae brief. I said, what are they concerned about in this issue? It was in support of the city. They said we have to stop clearing forest, taking farmland, and the open spaces in our suburbs for these big industrial parks and office parks. We have to start renovating our urban centers and the soils in our urban centers. That's where it could be. So the environmentalists supported us, saying stop taking land in suburbia, put it back, renovate our urban areas. And that made sense to me.
I'll add just one thing for context. You might think distressed municipality would be something that would be unusual, or there would only be a few of those, and that's actually not the case. I don't remember the exact figure, and maybe Tom does, but a very substantial proportion of the municipalities in Connecticut were designated as distressed municipalities, so the chances are, if you're worried about eminent domain, you're living in a distressed municipality, so that's not going to be a lot of protection for you.
I'm Don Rogers. I'm the historian of the group. I'm wondering about where the case figures historically. On the one hand, Mr. Neely describes this case as un-American. He talks about a wide public outcry against the case. But on the other hand, Attorney Horton remarks that precedent was one of his first magic words, 4 words. So I'm wondering, is this case a radical departure from constitutional law, or very much in the mainstream?
Maybe we need an impartial party to say something on that.
I'd rather hear the partial parties.
I would love to address that question. I wrote a book recently called Terms of Engagement, How Our Courts Should Enforce the Constitution's Promise of Limited Government. It's an awesome book. I hope some of you will check it out. And I actually address this question in the book because I think it's an incredibly important dynamic. The KELO decision was really met with a kind of a collective yawn by most of legal academia, judges, people in the know. And I think that's because in some sense it really wasn't a radical departure from precedent. In fact, people who are up on issues of property law felt that it was just, a routine application of existing precedent. Where I think some of those people miss the boat is they don't realize that the average American isn't up on Supreme Court precedent and didn't realize that the Supreme Court has been throwing property rights off the back of the constitutional sled for decades. And the other problem is that the case that preceded this one, the Hawaiian Housing Authority v. Midkiff, was a really unique use of eminent domain to try to correct a land oligopoly in Hawaii. Basically, most of the property, I think, on Oahu was owned by a few landholders, and that became kind of intolerable because people had to rent instead of buy. And that's where that case came from. Well, nobody thinks of themselves as being able to, basically have their home taken in order to correct a land oligopoly. It doesn't happen in any other part of America. So when KELO came down and people realized, wait a minute, you're telling me that if I have a modest little beachfront bungalow and some developer wants to put a condo where my house is, that they can just take it? If they have more political power than I do, then I will lose my home? That's why the case was met with such overwhelming outrage and revulsion by the American public, not because it was radical from a constitutional standpoint, but because the American public finally, the light went on and they said, oh, wow, I've got nobody backing me up if some developer comes along with a PowerPoint presentation and a bunch of promises to the town about how they can increase their tax base by bulldozing my house. That's scary to me, the hypothetical homeowner, and it should be. It is scary.
Actually, if I were to argue the case going forward, I would like the KELO case, because I would like to say to any other community, look what New London did. They put $70 million into the ground. Look at all these substantial and significant public improvements. Where is it in this case? So I think the Institute for Justice is going to like the KELO case because they're going to take the facts of the KELO case, the substantial public improvements and benefits, compare it to future municipal development plans in other cities, and I think KELO is going to be a significant factor going forward.
I would just, I mean, I didn't engage with you in my presentation, but I would simply say that I think you'll see it in panel 3 today about post-Kelo legal changes. There have been far fewer changes than one might have expected from all the public squawk immediately after the decision came out, because as legislators started looking more closely at it and seeing their arguments on both sides of this issue. It's not like Plessy versus Ferguson or the Dred Scott case, notwithstanding Justice Scalia's pontification on the subject. People have seen there are two sides to this issue, many of which on our side has been made very eloquently by Tom. And also, you didn't mention, while you mentioned the Hawaii case, you didn't mention Berman versus Parker. And I think you and I would have to agree on that. You certainly would condemn, you wouldn't try to find a way to justify Berman versus Parker, I would guess.
No, but I would emphasize it was a different case because it was about slum clearance, and the question was basically whether you can grab other property that's appurtenant to the slum. I disagree with that part of the decision, but I certainly don't disagree with the idea the government can try to remediate slums.
Sure, and that goes back to the point I made to the first questioner, which is if you can't do this, then what you're going to do is be having minorities taking the brunt of the problem, because slum clearance means minority.
If I could just clarify one thing also, is that New London had 6 plans to consider, 6 municipal development plans. 4 of the 6 had integration of the existing residents as a plan. Unfortunately, the timing of this lawsuit was such that when it was taken, New London NLDC had already taken 83 of the 90 property owners' homes. 11 properties were left out of the plan. I mean, we were so far into this plan, so far committed. I have a recollection, and though it's 10 years later, I have a recollection of meeting with the property owners because they were spread out in 2 different lots, not connected. Our expert called it the spotted leopard. What do you do with these spots all over the place? We talked to them about moving people from parcel 4A to 3B, or 3B to 4A, and each property owner basically said no, they wanted to stay exactly where they were. So we did broach that subject, but it didn't go anywhere. Yes.
And Attorney Londrigan, that was actually my question, because Attorney Neely had pointed out that from his perspective and that of the Institute, that it was a failure at conflict resolution that really led to the lawsuit, and that had there been, your case, I have to say, Counselor, was so compelling as to why this was critical for the urban center. I have never heard it put out that way in such a definitive manner, and I did learn from you, Mr. Horton, to not worry if you can't finish your argument. Just find a good reporter outside and your case is made. A good lesson for all of the young lawyers here. But, from a mediator's perspective, it struck me as I was sitting here, well, this was a failure of conflict resolution. Why? How? And I think I'd like to hear more about that, and why couldn't the conflict be resolved short of the mayhem that ensued? It
was going, I think from NLDC's point of view, what I said, 83 of the 70 property owners, they sold in a minute. If you look at the area, this is not a place where people wanted to stay, and if they had absentee landowners, they had trouble owning this property. I mean, they quickly sold most of the properties. So by the time this lawsuit was brought, it was a very difficult time to start trying to reverse. I don't know what I would have said to the 83 property owners. Sorry, we now going with an infill strategy? Maybe you could have stayed. It was so far down the road at that point. If the timing of the lawsuit was sooner, I believe there would have been discussions along those lines, and there would have been mediation along those lines. But unfortunately, it didn't happen.
Well, unfortunately, recollections differ. I wasn't involved in that meeting. I wasn't there. I do know that one of the leaders of the project for the City of New London, Claire Gaudiani, who was then president of the NLDC, testified in her deposition that retaining any of the existing properties was quote-unquote inconsistent with the municipal development plan. So at least at a certain point, the City of New London definitely took that off the table. I don't know that it was ever on the table. I'm not disagreeing because I wasn't there. But certainly there was a point when the city absolutely would refuse to consider retaining any of the properties. That much is clear.
I think we've got time for one more question.
I'm Mike Cristofaro. I sat here and, of course, bring back a lot of bad memories. My family was one of the property owners in Fort Trumbull. And, of course, we're not here to, debate the whole case all over again. But one of the points that I did just hear Attorney Londrigan state was that their property owners were unwilling to move into Parcel 3 and to remain in the neighborhood and put this all to rest. Yes, that offer was brought to the table. But why don't we finish that statement off by stating that it was only given to the original property owners, and when those property owners passed away, those properties were going to be turned over to the city and destroyed. So again, our rights were being taken away by not allowing the property owners to give these homes to their families, sell it outright, which is, I think, is what the Constitution really meant. But like I said, there's a lot of other points that were brought up here that we could stand and debate to the end of Earth, and we'll never come to an agreement. But I just wanted to point that out, that this was only a one-way street for the City of New London, and that was basically take these people's homes and tear them down and turn them over to a developer. Thank you.
The speaker is Matt Derry, one of the plaintiffs in the, Mike Cristofaro, I'm sorry, Mike Cristofaro, one of the plaintiffs in the KELO case. I do remember the offer that you spoke about, but I don't recall that it would only be for your lifetime, but it was 10 years ago. It was 10 years ago.
The last question. Okay, so he's declined. So thank you so much to the panelists, and thank you to the audience.
Glad to help.
Yeah, that was great. Thank you so much.
What time is lunch? I may.
So 12:05.
Okay.
Yeah.
If I can, I will.
Yeah, okay, great.
Okay, good.
It's unfortunate, I mean, that Scott can't be here. Scott's an old friend, Wes is an old friend, Tom's an old friend. We look back 10 years. We're still arguing about the decision, right or wrong at the time. And I have to say that I will agree with Clark that I don't think that, and I represent both property owners and governments at varying times in eminent domain cases, and I don't think it was much, if any, departure from the law. But it's exactly as Clark said. For the first time, the general public was galvanized. Their attention was drawn to this. I had T-shirts made for my friends on both sides of this issue that said, "Winning the battle but losing the war?" ? Which was pretty much how that case has turned out. But yet I also agree that the 40-something states that amended their constitution, statutes, and regulations in some form or another have not caused a dramatic change. But I will tell you this, as someone who practices in land development for property owners, developers, governments, and opposition groups, there has been a remarkable chilling of government's interest in using the eminent domain power for anything. I had an instance of a subdivision in a wealthy community which ultimately did develop with some affordable lots and development in it. But what was really needed was a turning lane to avoid adverse impacts on traffic on the main street by the subdivision. There was one holdout property owner who would not give us a construction easement and a slope easement just to cut back at the front of her lot to make this turning lane possible, an improvement that would have cost our developer client over $1 million. And the Connecticut DOT said, we are not going to use the power of eminent domain to take that construction easement and to take that slope easement, and the state and the community lost over $1 million improvement in a turning lane that was probably needed because they had conditioned the approval on it, and the subdivision went ahead. So there are things that are going on as a result of KELO, and it is good to look back 10 years. But we're here today, and we live in a reality that reflects what's happened in KELO, and we need to look forward. I was fortunate, and thank you, Professor Berger, so much for putting this together. It's a wonderful day, and I'm both pleased and privileged to be able to moderate this session. But I actually had a history of the site that went back from the time I came to Connecticut in the mid-'70s and sailed and anchored and moored in those areas. And then, I think practically nobody here knows it, 10 years prior, during the Gulf War, as a Navy Captain Surface Warfare Officer, I commanded the reserve component of the Naval Undersea Warfare Center, and that was one of our labs. I spent an enormous amount of time on that site, as well as the Newport Lab and Keyport in Washington and Andros in the Bahamas, in that capacity as the commanding officer of that unit. And then my firm represented Pfizer in the development of the global research headquarters that was ultimately built there. But it wasn't until after the decision, when Mary Massaroon Ross and I wrote a book, edited a book on the subject, that I really became familiar with what has gone on. So now what are we going to do? We got KELO, we got people still fighting about sort of what it means and what the impact is. What are we going to do today? Well, one of the things that the U.S. Supreme Court said, of probably 3 basic criteria for having a defensible use of eminent domain in this context, was planning. What is the role of planning? And we're going to start off with that, with Professor Garnett talking about planning generally. Then Professor Lamar is going to bring it down to the ground a little bit more and talk to us about why we just can't look at eminent domain as a holistic, one-size-fits-all, but we've got to break it into pieces, talk about individual types of issues addressed in eminent domain. Then, we got 2 lawyers, we got an economist, but we got a planner to keep us honest. The Director of Planning and Economic Development for the City of Bridgeport is going to bring to us the practicalities of doing what he has to do with or without eminent domain. And then to find out if what the professors tell us and what the planner tells us, we turn to the ultimate expert, the economist. What is the dollars and cents of eminent domain? What is defensible economically and what isn't? So we're going to spend about 12 minutes with each of our speakers. We're going to be done at 12:05. We're going to have about 20 minutes at the end for questions and soundbite comments and the like. So, Professor Garnett.
Thank you for organizing this great conference and putting together such a great interdisciplinary approach to what is really an important issue, and I'm honored to be here. I want to start out with a few words about my priors, which probably will upset both sides of the issue. The first prior is the case that most upset me in law school was Poletown. Very much upset me, smoke out of my ears. So my strong intuition has always been that the public use requirement is not a scrivener's error, and that the risk of eminent domain abuse is real and pervasive. The second is that I was an attorney at the Institute for Justice. During the time that the KELO case started percolating, I did not work on the case, although I supported the effort, but I didn't expect to win. In fact, I think I really upset my colleague Scott Bullock when I wrote in a blog after the KELO case, I can't believe you got 4 votes. I mean, I actually thought it would be 8-1, Justice Thomas being the one, of course. So, and I was surprised by that. I wasn't actually surprised by the outrage. People talk about being surprised by the outrage. I wasn't surprised by the outrage because I remember being outraged, and all my students tend to be outraged. So the third thing is, I want to say some things about eminent domain and planning and public use. And in saying these things, I want to make clear that I'm not naive about the incredible challenges facing our urban centers. I've researched a lot on cities. Most of my research focuses on issues facing poor urban neighborhoods. And I thought a lot about how to help them. I'm not a fan of economic development takings, especially large-scale ones, as one of the means of helping them. And that is with full awareness that holdouts are a problem. As are holdouts being people who are rent-seeking, right, to get more, to take part of the assembly value. And hold-ins are a problem, like Suzette KELO. She's not rent-seeking, she just wants to stay. They understand that that can impede land assembly. And economists, especially lawyers pretending to be economists, which are the worst kind, and I am not one of those. Law professors always say, well, holdouts impede efficient land assembly, and the problem I have with that is it kind of begs the question about what's efficient land assembly, and just the fact that the government wants something doesn't make it efficient. And so I think if you look historically at what has made cities renew themselves, a lot of times the most successful efforts are organic, not wrecking ball projects. If one considers the difference between Georgetown in Washington, D.C., which was a slum, and Southwest Washington, D.C., which was a slum. One of them was torn down in order to renew it. Another one was a ground-up renewal effort, and I think most of you law students who are considering moving to Washington, D.C. will probably prefer Georgetown to Southwest Washington, D.C. So I'm skeptical historically of the claim that just because we want something to be assembled, it's a good idea. The final thing about my priors is I have taught property for 16 years, and I've taught public use to over 1,000 law students now, and the experience of playing devil's advocate with a bunch of outraged law students has actually led me to conclude that the task of articulating a workable public use test, and that isn't easily circumscribed with clever lawyering by city attorneys, is a lot harder than I thought it was when I was 22 years old. I think the only internally consistent opinion in the KELO case is Justice Thomas. I work for Justice Thomas, I clerk for Justice Thomas, but I actually think Justice Thomas takes things off the table that may perhaps should remain on the table, including taking property that has been abandoned or where we can't find the owner. Okay, so that's my priors. So now I want to talk a little bit about planning. So I wrote an article prior to the KELO case being decided that said that the court should impose meaningful means-ends review in public use cases. So it should actually ask if the government needs the property it wants to take to advance the goals of a project. This still makes sense to me. Rational basis review to me makes no sense in the public use context because it asks whether there's a conceivable purpose for the government action, and we don't take property for conceivable purposes, we take property for real ones. So I wrote a brief in the KELO case arguing this, and I got only one mention. It wasn't mentioned by name, but the majority dismisses this idea as ludicrous in a footnote. But it does endorse planning. And I think if you read the cases, especially Justice Kennedy's case, opinion, there is a sense in which Justice Stevens and Justice Kennedy think planning is going to serve the purpose of means-ends review. They think it will predict success or at least say, well, the government's thought hard about what property it needs. And they also think it's a way to weed out pretext, A to B transfers. So I like to talk about those two things in the 7 minutes that I have left. Okay, so to go back to my priors, I am kind of a planning skeptic, as you might have known. In particular, as a scholar of planning, and I've studied a lot of planning that failed, maybe more than planning that succeeded. As an academic at a major research university, I have been coercively forced into one too many strategic planning exercises, which I have found mostly are a waste of time and often are a sham. So I think that I draw lessons about planning in the eminent domain context from this as well. Okay, so the first, planning. Will planning predict project success? So Justice Stevens clearly thinks, look, New London thought about this. They worked hard on this. They consulted constituents. This signals that maybe they need this because this is the means ends review point, right? They really are trying to think about what project they need to accomplish and what land they need to accomplish it. The difficulty with using planning as sort of a predictor of proportionality and success is there's a lot of evidence that planning doesn't necessarily encourage either. There's plenty of historical evidence that misguided planning in the economic development context has led the government to take far more land than it needs to advance plans that fall short of their goal or fail outright. In fact, I think if a central historical lesson of economic development takings is that bad planning and eminent domain is a pretty toxic combination for communities. Now, that doesn't actually mean that I don't think that government should not plan. I think it's important that local communities take stock of their assets, understand the unique context that they're situated in, get input from stakeholders and constituents, think critically about strategic advantages and disadvantages, and ask hard questions about how to attract talent and capital in a competitive market. But a paradox of planning, it seems to me, is that all of the things that local government plans rightly target, like community assets, strategic advantages, resident needs and desires, those and preconditions for success are moving targets. And so the more a plan becomes ossified, the more likely it is that it won't be able to be flexible when those targets change. CEG, Atlantic Yard, which is now called Pacific Park, I don't get that, in Brooklyn. The market crashes and there isn't any building there, but we've already taken all the property, so we're supposed to be building buildings built by IKEA. I think that's actually true. So that's a problem. So the more you take property, the more likely the plans are going to become ossified, especially these large-scale plans. Okay, so that's sort of my concern one about using in the eminent domain context planning as a predictor of proportionality and success. But what about pretext? I'm running out of time, so I'm just going to sort of, Justice Kennedy in particular says, look, we know this wasn't a pretextual taking for Pfizer because look how hard they tried. Look how many people they talked to. And this is an intuitively attractive idea. It may even be right in a way, but because, I actually wrote about a taking in St. Joe County, Indiana, where the county in about a month and a half, because AM General asked them to, took 50 houses to give to AM General to build a Hummer plant, because AM General was promising 3,000 jobs. That seems to me to be a naked A to B transfer. There was no planning. They were like, please, 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 if we're going to go away. It was a classic Pool Town example. Incidentally, on the success of the project, the military stopped buying Hummers, and now the plant is defunct while AM General is attempting to use it to make new kinds of cabs, and I'm not sure they know about Uber. So maybe is multilateral planning less likely to produce pretext? Maybe. But is it possible that it can be pretextual? Yeah. I mean, most of the strategic planning exercises I've been a part of were a sham. The decision's already been made, and faculty are just called into a room to ratify it. That's true and annoying and a waste of time. But I think we all know that every government process can be captured, and planning is no exception. And I worry in particular about courts being able to discern, really collaborative planning from captured planning. I also worry about the fact that it's really hard to get, in large-scale projects in particular, the real collaborative input of people that are about to be displaced. They aren't going to get the implicit in-kind benefits of the project because they're not going to be there for the project. They're also not going to capture any of the surplus of the assembly. In fact, they probably are going to lose value when the plan is announced and everybody starts moving. And no one's buying into it because the capital and talent the city's attempting to capture with the plan is waiting around either to see if the project succeeds or to see if they can get free land. My last thought about planning and KELO is sort of related to the paradox of planning, that it needs to be flexible. It might be the second paradox of planning, particularly in the eminent domain context, And that is, I think that major projects, economic development projects, we were talking about this before, are likely to succeed if developers get involved early on, and rather than the city putting together a packaged plan that they go and try to sell to a developer. That was the lesson of urban renewal, to be sure. But it sometimes, just as Kenny and just as Stephen, sound like that's what they want. They want the government to come up with a blueprint and then just go and find Forrest Ratner to decide whether to develop it. But the project is more likely to succeed, it seems to me, if we're going to have one, if the developer is at the front end, because they can help shape the plan. So I think that's a second paradox of using planning in this context. And I am going to stop now with 30 seconds left. Thank you.
The standard's been set for timeliness, and I hope to live up to it. It's kind of amazing to me that it's been 10 years since KELO. This is what I thought of last night when I was preparing for this. 10 years ago, I had just started dating my now husband, and the case came down, and we were on totally opposite ends of it. We almost broke up, but then I remember thinking to myself, if I care this much about how wrong he is, I must really like him. So here we are today. So I want to thank you, Bethany, for putting this together. I want to hit on 3 or 4 points that I hope can stretch our thinking about what kinds of self-proclaimed economic development, eminent domain projects, and yeah, I'm going to call that ED squared, really spur economic activity. ED, really? Like, okay. Anyway, so now you have 2 pieces of evidence that I'm a huge dork. Awesome, okay. So first, the post-Kelo conversation tends to clump together all of these economic development, eminent domain projects. But for any given project, we ought to think about what the precise economic activity spurred by the project is. Is it new economic activity that would not occur but for the exercise of eminent domain? Is it economic activity that would have occurred elsewhere but for the exercise of eminent domain? And I think that part of the reason we all have this sort of response to Pole Town, for example, is we assume that that would happen somewhere, and that the exercise of eminent domain really is sort of thinly veiled corporate welfare. It's not developmental in nature. It's simple redistribution from poor to rich. And I think we'd all be well served to think about what it is that makes us angry. Is it the taking or is it the giving? A year after KELO, the Supreme Court demurred on another case that I actually thought was a lot more interesting, that involved municipal distribution of a public asset. In this case, the asset was tax subsidies rather than eminent domain power, but also to a private end user. In Cuno v. Daimler Chrysler, Ohio and Michigan taxpayers challenged Ohio tax subsidies that were intended to attract and retain manufacturing facilities and other types of employers. The case received nowhere near the attention that KELO did, but like KELO, it involved a desperate post-industrial city seeking to better its prospects by spurring economic activity. A challenge for those of us who worry about how it is that you craft effective local and state economic development strategies is how the political processes in the courts should work to ensure that eminent domain for economic development is used for real pie-increasing economic development rather than simply shifting economic activity from one jurisdiction to another with no attendant increases in efficiency and equity. Whether a property's end user is public or private doesn't necessarily answer the question about whether the exercise of eminent domain ends up being a developmental economic development strategy or simply a redistributionist one. The second thing I'd like to think about is that sometimes the value proposition inherent in the exercise of eminent domain is the disruption of dysfunctional property rights itself. That's not a new thought. That's Hawaii Housing Authority v. Midkiff. But it's not just Hawaii Housing Authority. I'd challenge the assumption that that's a sort of one-off case that doesn't exist anywhere else in the country. These aren't necessarily situations also where there's blight, as in Berman v. Parker, although blight is sometimes a symptom of a dysfunctional property right. Sometimes the property rights themselves don't further the economic activity, but instead limit it, and I'm going to give you 2 examples. One is a few blocks from my own office in New Haven. There is a commercial condominium project. It is itself a result of mid-20th century urban renewal, land that was taken and put to economic development purposes, although this, one of the purposes at the time was also highway development. So you can see this is sort of a jumble of issues in any given project. The Condo Association, in full disclosure, has at times, although not currently, been a client of the clinic that I teach. The urban renewal plan adopted and put into place in the late 60s called for a commercial condominium project for the strip mall on the assumption that property ownership would give the business owners a stake in the neighborhood. Today, the largest anchor unit, once a C-town grocery store, is vacant. A few of the units are controlled not by small businesses, but by the city and local nonprofits, or a library branch, a health clinic, and a local chamber of commerce. There's a bodega that's been the site of more than one shooting, and a beauty supply shop. 11 individual unit owners control 6.5 acres of developable property, 4 blocks from major research university that is constantly growing. Planning redevelopment of this site has been bluntly complicated. It is a very typical example of a holdout situation of particular interest, perhaps only because it is itself the result of previous governmental interventions in the local real estate market, including the exercise of eminent domain. A less typical example, but one that I want to bring under the fold of economic development eminent domain, is the contractual tangle created when, in securitizing residential mortgages, the banking industry divorced holders of mortgage debt from the power to renegotiate non-performing loans. This isn't the kind of thing that we normally think about when we think about economic development, but if we're talking about the sort of ground-up infill type of development that Professor Garnett wants to think about, I think it's important. The neighborhoods that are largely low-income, oftentimes minority, that have been victimized by predatory lenders, and places that haven't and won't return to pre-housing best property values, suffer various negative externalities associated with underwater mortgages. Homeowners with no resources to maintain and improve their properties, the failure of anyone to take care of a property while the foreclosure is pending, and later when the property is REO, vacant properties as magnets for crime, depressed housing values due to a glut of foreclosed properties in the pipeline. Another one of our clinic clients is a neighborhood association in a diverse mixed-income neighborhood, sadly plagued by foreclosures, and they're facing all of those above negative externalities and more. And the foreclosure-related problems that we see in New Haven are actually minuscule to compare to those problems in other parts of the country that had higher booms and lower busts. Unfortunately, while lenders and borrowers alike would be well served to write down principal and otherwise restructure that mortgage debt, fractionalized ownership and contracts that bifurcate ownership from management make write-downs unlikely, if not possible. And here, some local governments have explored a strategy proposed by Robert Hockett at Cornell to use the eminent domain power to take the non-performing mortgages and transfer them to private entities, A, B, that are themselves structured to write down the debt. Hockett assumes that the value created by facilitating the write-downs would be sufficient, that there would be no net municipal expenditures. This strategy is clearly eminent domain for the purposes of economic development, really reviving these communities that are suffering the negative externalities associated with the foreclosure crisis. It is an eminent domain proposal clearly intended to spark economic growth, or at least stop the bleeding in desperate places. Under Hockett's plan, bondholders from whom securities are taken would actually receive rights of first refusal to participate in the new pool. And on the ground, none of the homeowners would be displaced. The ultimate goal, the point, really, is to keep the homeowners in their homes. And I hope that that kind of stretches our understanding of what ED squared is. But Hockett's promise of a right of first refusal of just compensation for the taken mortgages also brings me to my third point. If the value proposition from an ED squared deal is real, there should be an opportunity to create space for the original property owners from whom the property is taken in the ultimate development project. And I'd really contest the assumption from some today that that never happens. In part as a result of the failures of urban renewal, we have a better understanding of the public health implications of dislocation, which some have compared to post-traumatic stress disorder. We better understand the aesthetic benefits associated with historic places, as Professor Garnett referenced, and the economic benefits of dense communities with extensive personal and family connections developed over time. And for those reasons and others, local governments have adopted really sincere community-oriented planning processes, or at least in some cases been forced to in the context of high-stakes litigation. And an increasing number of these projects now involve a right to return, a right on the part of displaced residents to return to new housing units in the redeveloped parcel. Dislocated residents have had the option to return to redeveloped places in the Freetown neighborhood of Greenville, South Carolina, Mount Holly, New Jersey, litigation, and Melrose Commons in the Bronx, which involved a community organization, a former client of mine from my legal services days, whose name, Nos Quedamos, literally means we stay in Spanish. In some parts of the country, the dominant economic development strategy is no longer Pole Town. The assembly of a large lot for a single industrial end user isn't our vision of economic development, but it's Melrose Commons in the Bronx, which is a mixed income, mixed use community that's really intended to take advantage of the benefits of living and working in dense urban places. For that matter, the model really could be the original plan for Fort Trumbull, as Tom Londrigan showed us. The project was too often painted as a clean corporate giveaway to Pfizer, but it really was a mixed-use development that included multiple components: residential, office, tourism, and park uses, a real attempt to capture the spillover effect associated with Pfizer having located in the city a few years before the redevelopment process began. So I've got 2 minutes for my fourth and final comment, and I think I'll be quicker than that. Like Tom Londrigan, I really want to situate eminent domain for economic development in the context of redevelopment defined broadly as any reconceptualization, government-initiated, or preferably not, of an already developed neighborhood. As a general matter, our property law, our regulations, our tax structures, our property and liability rules are all completely ill-suited to the problem of redevelopment. And we're in a moment now where that's really quite important. 70 years after the post-war housing boom, we can look back, I think, and wonder whether, in light of the documented benefits of agglomeration, a generation that's expressed a renewed interest in living in our cities, we can wonder whether many of our suburbs in particular are ripe for redevelopment alongside some of our cities. Unfortunately, we're faced with zoning that calcifies existing development patterns without regard to future market demands, restrictive covenants that create extreme holdout problems, local control of land use, property tax regimes that look to current use rather than the possibility of use. All of those legal mechanisms really fail to serve redevelopment goals. Ultimately, eminent domain for the purposes of redevelopment feels like ad hoc tinkering with a system that was structured to facilitate the use and development of greenfields, not to enable redevelopment. Over 20 years ago, well before anyone could have imagined, as a number of internet trolls have suggested, that we'd have an African-American president who wants us to give up all our cars and live in apartments because he has programs called sustainable communities. There actually was a scholar who proposed condemning single-family neighborhoods bordering on multifamily neighborhoods to densify the housing stock and increase affordability in fast-growing Seattle in the early 90s. That is an admittedly Swiftian proposal, and I would not put it to you now, although maybe it's a good law professor hypothetical. But I do believe we have a larger challenge to imagine a property and land use law system that's capable of reimagining redevelopment with or without the use of eminent domain.
Thank you.
Morning, everybody. As was mentioned, I'm David Corse. I'm the Director of Planning and Economic Development for the City of Bridgeport. I'll apologize first, as I may have to sneak out before the panel's over to get back to Bridgeport for a meeting, though hopefully I won't be doing so out of embarrassment for being the only non-lawyer up here. I definitely don't understand the intricacies of the cases as probably anyone in this room, but I do have to deal with these tools on a day-to-day basis. In fact, literally this morning during the first panel, I received an email from staff with the headline taking, and the subject was, you know, we can't deal with this owner anymore. We have to take this property. Give me direction how to advance. And issues like that come up on a weekly basis. I'm going to try and avoid, you know, details of projects. I don't certainly want to stand up here and pretend that you know, I could come up with a better plan for New London, and I don't want to bore you all with the details of projects in Bridgeport. There's been successes, there's been failures, there's been good use, there's been bad use, but I think I want to talk more generally about the tool, why it's important, you know, maybe a different way to think about it from a user's perspective within municipal government and particularly within Connecticut. I want to expand on a couple things first that Mr. Londrigan spoke about this morning related to some of the structural challenges we have in local government in Connecticut. I think, you know, as folks are aware, there's 169 municipalities, the state's completely subdivided, and they are not all created equal. And I'm not talking about from the perspective that was mentioned this morning about pockets of poverty and the concentration of social services, but just literally the actual land base that we have to begin with. Those 169 municipalities range in size from somewhere around 8 square miles to somewhere around 52. And we've told local governments that they need to be almost wholly dependent on property tax for their ability to raise funds for local government. And there's a very different situation if you're starting out with 8 acres or you're starting out with, 8 square miles or you're starting out with 52. New London happens to be about 11. Bridgeport happens to be about 16. Many people talk about the difference between Stamford and Bridgeport as if it's wholly due to difference in governance strategy or economic development strategy. Stamford's 30 square miles. When offices left downtown in the 1960s and 70s for office parks up at the suburban interchanges, they were still within the city limits. When they left downtown Bridgeport, they only needed to go 4 or 5 miles before they crossed into another municipality, and that tax benefit was lost. The boundaries that were created centuries ago have a huge, huge impact on our ability to self-determine our future. We have then within our municipalities the tax-exempt uses. Bridgeport, 16 square miles, not dissimilar to the New London instance. About 50% of our assessed value is tax-exempt. And this isn't just nonprofits and churches and synagogues, although that's a lot of it. It's universities. It's the only 2 regional hospitals. It's regional parks. It's highways. It's a series of state, federal, local, and institutions that meet the needs of a larger population that is not subject to the antiquated boundaries that exist on a map. We all cross these borders every day, but they were put in effect when the determining factor over municipal borders was how far you could ride from a Congregationalist church by horseback in a day. Completely irrelevant from today's purposes, yet the residents that are born in Bridgeport, the young people attending elementary and middle school that are living in impoverished neighborhoods are completely dependent on the fact of where those lines were built, even though they have nothing to do with it, and they should be held harmless by it. There's also a failure of the marketplace. Not only do we have limited land, that land in many ways is incredibly constrained because of the industrial history. We talked about the landfill, or the filled land in New London. 16% of the city of Bridgeport's 16 square miles is within the floodplain, within the 100-year floodplain. Much of that was filled. They talked about pilings. We have to build on piles in coastal land. We have to remediate brownfields. We talk about the devaluation of land in the cities. In many instances, our property has negative value. In many instances, the assessed value of $100,000, $150,000 per acre is when it is buildable, after the land is remediated, once the ground conditions can support building. So in some instances, you can have value of negative $1 million per acre just to get that land ready to be built to create some economic value for the community beyond. And because of all these factors, any private entity who you're inviting to engage in a public-private partnership with local government is taking on a tremendous amount of risk, a risk that is often not offset by the reward. The returns that we see on downtown redevelopment or waterfront redevelopment in the city do not justify the risk. And for many instances, people are doing it because they're interested in the challenge or excited about the opportunity or perhaps hopeful for the eventual glory of being part of that revitalization. But oftentimes the scale of the project is the one justification that you can provide to take on the risk that exists within these urban communities. I want to though talk, I think, a bit more broadly about economic development and reference a quote from this morning. There was, in the context of takings for economic development being unpatriotic, there was the comment that it's not like something that we really need, like a highway. What is the purpose of a highway? Because I would argue that in most instances, while the Department of Transportation can say that they're not involved in economic development and they're purely investing in mobility or access, at the end of the day, it's about adding value to the properties that it passes through or that it provides access to. So when we look at highways like the Cross Bronx or we look at highways like the Route 825 interchange in downtown Bridgeport, that's dozens of acres of developable land within the city of Bridgeport that was taken for a purely public purpose of a highway, reducing neighborhoods within the city limits, many of them minority, for the purpose of providing economic development in adjacent municipalities, for the purpose of making it easier to get from Trumbull and Monroe to the coastline, to I-95, so that they could create industrial parks, so that they could create office parks, so that they could create housing and developments. So it's not just that the road is purely for transportation purposes, but it has an underlying economic development implication. Many of the instances at the expense of the city who bears the brunt of the takings. And the same could be said for parks or for schools. We just did a study that parkland adds an average value of 7% to the surrounding properties. Parks are about creating quality of life, increasing value on the surrounding properties, which I would argue is part of economic development. Schools are about creating a quality educational offering for our residents so that they're more likely to want to live there, which increases the value of the properties within our municipality or our school district, also economic development. So this idea that there's some drastic or dramatic difference between takings for a purely public purpose like a road or a school or a park, and that's somehow dramatically different from takings for economic development, I think misses the understanding of why the public sector makes investments in infrastructure. And on that point, I do want to mention, I don't know if folks are aware, but there is a bill before the legislature right now, 6851, which looks to give the state the increased development powers, including eminent domain, within walking distance of train stations, transit stations throughout the state. It's obviously not without controversy, but one I suppose I'll be a bit provocative around to say that when the state makes an investment in transportation infrastructure, like a train station that's designed to add value to the surrounding properties and the surrounding communities, should there be a tool for government to ensure that the return on that investment is as great as it can be, because we have collectively invested in those roads, in those rail, in those stations, in the bus rapid transit corridors, and maybe we don't want to leave it to municipalities to limit the potential for us to collectively create a return therefrom. I think I could expand this argument. We focus significantly on climate change and sustainability within the city. We have an award-winning sustainability plan. We are focused on the fact that a resident in the city of Bridgeport, obviously income being a factor, but transit orientation, multifamily, mixed-use development, walkability being a huge component, produces about 1/3 the amount of emissions per capita as a resident of any one of the surrounding towns. I don't think there's any better public purpose than reducing emissions and mitigating the impacts of climate change that's facing our state and facing our community. What if there is a property that's preventing intensification? We've heard about the benefits of creating mixed-use, walkable, higher density development, but there's the climate change component. That's to say that if we know that every housing unit on a site near a train station is going to produce 1/3 of the emissions per capita than a single-family housing unit out in the countryside 5 miles away, then there is a public purpose beyond purely the tax impacts and the revenue impacts of intensification and greater utilization of properties in an urban environment. So I'm sure I've probably stepped on a million different constitutional issues or got myself tied up on legal things, but the reality is we are trying to squeeze productivity out of a very, very limited resource, the most limited resource we have, which is land. And it's not just as simple as taking from one entity to put it in the hands of someone else, but it's about making sure that we can provide for our residents by making the most out of the landscape that we were given by folks several centuries and generations ago. And I would urge folks to take a broader perspective on what we mean by public purpose when we think about transportation and more traditional uses of land through eminent domain. Because at the end of the day, it's really all about adding value to our communities through quality of life enhancements, through economic development, through public improvements that can take on many, many different forms. Thank you.
All right, Professor. Is it all worth it?
Well, we'll see. So I'm an economist who sometimes pretends to be a lawyer, so I don't know if that's worse or better than the previous situation. In any case, I've been thinking about eminent domain as an economist and from an economic perspective for probably more than 25 years, well before the KELO case and even before the Lucas case, which many of you know was another case that raised a lot of uproar in the public. But the KELO case gave me an incentive to focus specifically on the public use aspect of the Fifth Amendment, which, as you know, is one of the two requirements that has to be met before eminent domain can be used along with just compensation, about which I'll say something in a few minutes. I think the plain meaning of public use suggests that eminent domain should be based on what economists call provision of public goods, or as the court has recently construed it, to provide a public purpose, kind of a very broad term. And so based on this logic, the KELO case, which echoed previous Supreme Court cases and state cases like Berman and Poletown, emphasized the jobs and the tax revenues that the redevelopment plan promised, and what economists would call sort of the spillover benefits of what otherwise appeared to be largely a private development project. In contrast to that, economists, when they think about eminent domain, which essentially is a forced transfer, it's a coercive transaction, very different from an arm's length market transaction, economists think about it as overcoming a holdout problem, which is a form of market failure or monopoly power that arises in cases involving land assembly. Now, it is true that the idea of a holdout problem has been in the literature, I think, both the legal literature and also in the economic literature, somewhat of a vague notion. I think people know it when they see it, but they've had somewhat of difficulty in formalizing it. And so one of my interests has been spending some time in the last few years trying to be a little bit more rigorous about what we mean when we say a holdout problem. I'm not going to go into those details. That would be outside of the scope of this, but I think we've accomplished some of that. But in any case, the implications here is that, as I see it, there's a divergence or an apparent divergence between what we say is the legal economic meaning of public use and the economic meaning of public use. And this raises two questions, the first of which is, why does the court not ever resort to holdout language in justifying the use of eminent domain? So if we think about eminent domain as sort of the means of acquiring land, economists would focus on what are the problems in the land market that make that difficult to do, as opposed to what is the land going to be used for. So that's the divergence, right? The legal argument focuses on the use of the land. The economic argument focuses on the manner in which the land will be acquired, which to me as an economist is the proper way to conceptualize this. I think the reason courts don't do this is obvious. It's because the Constitution, the language of the Constitution uses literal public use language, which sort of says, you have to talk about how the land will be used. It's almost required that you take that approach to it. That's at odds, by the way, with other areas of law, not constitutionally based law, where courts often do use holdout language to justify liability rules or other kinds of coercive transactions. So it's not that courts don't understand this logic, it's that I think they feel compelled by the language of the Fifth Amendment to pursue this public use language. The second question, or the second issue that arises from this divergence, I think, is, does it matter? In other words, does it matter that courts don't follow what I would call the strict economic approach to public use? And I think it depends on, the answer to that depends on the incidence of two possible errors. One is the possible overuse of eminent domain. That is, again, from this perspective, using eminent domain when it is not required by the nature of the situation in the land market. That is, if it would be used in the absence of a holdout problem to acquire, say, one parcel or something of that nature. But some prominent law and economic scholars, those who I admire very greatly, Bill Fischel and Tom Merrill, have argued that this is not a serious problem because the cost of using eminent domain is so high in terms of litigation costs, and I'm sure the lawyers who spoke in the first panel would attest to this. It is a very costly process for both sides, and for that reason, it makes it unlikely that cities or developers will use this strategy unless it's sort of the last resort. So in other words, these scholars argue that this is a self-limiting problem, that this overuse is not a severe problem. I think that's an empirical question, but I think it's a fairly reasonable argument to make. The other possibility, the other possible error is underuse. That is not using eminent domain when it is appropriate because of the situation in the land market. And here's where we get into this area of private development, right? Development projects that are largely private, but nevertheless are subject to holdouts. So land developers, I'm sure, could give all kinds of stories of this sort of thing happening. The KELO case is sort of a hybrid because it was kind of a private-public partnership, and it certainly did fall prey, I think, to holdouts. And so I guess if I were forced, and this is sort of the cocktail party answer I give when people ask me what I think of the case, I say, I think it was the right decision, but for the wrong reason, right? That it overcame the holdout problem, but the reasoning the court gave was incorrect. It really shouldn't be focusing on the use of the land. That's not really relevant from an economic perspective, but it did create a lot of, I think, uncertainty about what exactly this public use provision really means. And it has led a lot of scholars to say public use is really a dead letter, right? I think that may well be the situation. So let me now turn to the just compensation requirement, because I think it's impossible to separate these two provisions. They're not really distinct. They kind of are two sides of the same coin in my view. The problem is that just compensation has been defined by courts to be fair market value. That's pretty much standard. It's not debated anymore. But economists recognize that fair market value almost certainly systematically undercompensates landowners. And if you doubt this, just imagine if any buyer had a call option on your property at a strike price equal to the market value. I don't think we'd be very happy with that kind of situation. But that's effectively what the eminent domain clause is. It's a call option at that price as limited by what the courts say are those circumstances in which it can be used. And at the moment, there seems to be fairly few limits except this self-limiting situation that I described a few minutes ago. The problem really is, therefore, that it is impossible in a KELO type situation to distinguish true holdouts, that is, those who are opportunistically seeking to profit from their market power, from those who truly have high subjective values. And I think Suzette KELO, and I'm sure some of the others in the audience may well fit into that situation. Right? When I was writing a book on this topic, I read the book by Jeff Benedict. I'm sure many of you have read it, and there were some very compelling, individual stories there. And it suggests that, yes, many of these sellers who were reluctant to sell truly did value this location. And in fact, I have personal stake in this, in that my father grew up about 2 miles from this site, so I know it very well. I knew it as a child, and I can see that there would be, significant attachment to it. Economists treat those values as real. So when we say subjective value, it's not a frivolous notion like emotional attachment or whatever. Economists treat that as real because that's really what private property is all about. So there really is this debate about balancing, protection of private property and subjective value against the legitimate need to have tools to overcome holdout problems. All right, and that to me is the crux of this problem. I don't think there's an easy answer to it. But this is where the role of the court in setting a limit to these coercive takings is really important. Let me just conclude, and I'm actually going to finish early here, that efficiency, and by the way, it was said earlier by Professor Garnett that, this idea of holdouts, we don't really know what it means. And that's true, but efficient land use, it's not really clear what that means. Economists, that's our whole job, is to kind of figure out what it means to use land efficiently. There are ways to do that. People may disagree with it, but that's our job, right? We specialize in that sort of thing. But that doesn't mean efficiency is the only thing we care about. We also care about fairness, and there's no doubt that there's a fairness dimension to the eminent domain clause, I think in two respects. First of all is the undercompensation problem associated with fair market value, people who are paid for just compensation. That doesn't mean they're as well off as if there had been no taking, because they are systematically, I think, undercompensated, and especially families that have long histories and so forth. There is also the second point, and that has to do with the idea of which neighborhoods are going to be the targets of redevelopment. Yes, slum neighborhoods tend to be low income, but so do these neighborhoods that are targets of economic redevelopment. That's the whole point of economic redevelopment, is that those properties are underperforming in the public budget. Higher uses will generate more tax revenues. That makes it a very tempting target for local governments to try and redevelop those areas, and that can create a disproportionate effect on low-income households who live in those areas. It can also create a danger of reducing the supply of low-income housing unless the development project and the plan explicitly provides for low-income housing. I don't know if the KELO plan did that or not. It is becoming more necessary for developers to provide low-income housing as part of their plans to get approval. That certainly is a desirable development in view of the possibility that redevelopment will tend to favor, obviously, high-end development projects. Thank you.
What a fabulous panel. You know, you can't see it from down there, but I can see it from here. Everybody was riveted on our speakers who were totally disciplined. I mean, let's thank them again for really. I mean, I'm going to open it to questions, but I got about 100 here right now. And Lisa, maybe I'm going to borrow your microphone. I'm going to walk around and pretend I'm Phil Donahue or somebody. But, you know, what is the role of planning? I mean, what is the role of planning? What do we mean by planning? How do we get property owners the assemblage value, which is part of the way they're getting cheated? Do we do that with land assembly, which is a private technique followed in Germany and other countries, with a government help for the holdout? Who is the holdout? We seem to have kind of an acknowledgement that holdouts are a problem and we need to address them, but there's holdouts and there's holdouts. How do we decide who we really need? What about leaving somebody, like Cristofaro and his family and the other families who were affected? What about the use of life estates? What about, let them stay? Is it that important we do this development this year? Nothing happened in New London. It's been 10 years. Why couldn't we waited 10 years and let some of the people who are 85 years old and older live out their lives in that home? I don't know the answer to that question, but what the eminent domain technique, it seems to me, from the conversation we've had thus far today, is somewhat inartful, at least. And what about ombudsman? We gave up our ombudsman in Connecticut. Do you remember those? How many of you remember we had an ombudsman? Utah does. I think Missouri did. Craig Call, who was the ombudsman in Utah, told me that the Utah Department of Transportation loved the ombudsman. Why do you think somebody who takes property more than anybody else would like the ombudsman? Because their number of cases were cut in half. When property owners like the Cristofaros and others were empowered by having an advocate who would step up on their behalf against the government's taking. Why aren't we doing that? All right, let's get down and get among you and get some questions and comments. Soundbite questions and comments, soundbite questions and answers. All right. Here when I grow up. This is where we usually go. Like this. Doesn't he usually do something like this? Well, what do you think, Professor Merrill?
I think, Dwight, you're great.
Yeah, anybody else want to say that? We'll go get them. All right, comment back here. Go ahead, please. Everybody look back here. Please.
Hello, everyone. My name is James Mason. I'm an assistant director in the Office of Rights of Way for the Department of Transportation.
Oh, my goodness, here we go.
I have a question. You mentioned that one big part of it is just compensation with respect to eminent domain. What I haven't heard anyone speak to is, and I'd like to hear from the gentleman from Bridgeport, is the degree to which towns obligate whoever is in charge of the relocation side of the project, obligate them to provide the displacees with all the benefits that they are truly entitled to, because that's where a lot of the just aspect of the process comes into place. And it's been my experience that that piece of the process is kind of dismissed or not really focused on to the degree that it should. So I'm interested to hear what you have to say with respect to the
Well, so we're talking about relocation benefits. Last night we had a very spirited discussion that maybe tenants, who I thought were the most abused in the process, are actually pretty well off in terms of the benefits they get. What do you think?
Well, the limited experience I have with this has to do with Steel Point, which is probably a project that most folks are familiar with. 52-acre peninsula taken through eminent domain over the course of 15 or so years. And when I joined the city of Bridgeport, we had 2 tenants left after that time. And yeah, I think that your assessment, Dwight, is probably accurate, that tenants tend to get maybe a little bit better treatment than owners in that aspect, because their situation is so different. And I'm stepping a bit outside of my comfort zone here a little bit, but I can say that with the tenants, we feel a greater responsibility to provide them with more of a similar condition than they're in presently, whereas owners, it's much easier to think about it as writing a check, right? They own a piece of property, you're going to compensate for it. It's then up to them to do what they want with those resources, whether they want to replace the position or not.
Nicole, you have a comment?
Well, yeah, actually, so Tom Merrill has an article that says tenants are systematically undercompensated. I don't know if he's right. I did write about relocation assistance because I studied this project in South Bend where they actually, money was not an issue. They were so desperate to get people to sell out, they gave them about twice what their property was worth. They wanted them out so fast because they were going to lose this contract with AM General if they didn't get them out in 6 months. So I think really how much people get is very much not just a result of what the law says, but what the political circumstances and the urgency and also whose money they're spending. So Bill Fischel, you mentioned, has this article that says it depends. So a lot of these takings cases, sometimes the local government is spending federal or state money that's given to them only to take property. And so they have an incentive to overtake because they can't, it should be given to them to do other kinds of redevelopment techniques.
Well, so that certainly happened in Connecticut. There was a lot of overpayment right before Governor Rell was going to run for in her own right. Thomas?
Well, just one other thing on relocation. I think the evidence that I've read, and you may know more, the relocation assistance, the people who get hurt the most are businesses. Because they aren't paid for goodwill, they aren't paid for location. Cities may worry about what the school system is and the size of the apartment and other things, but businesses are, often the business value goes down because of the project and they get undercompensated.
Well, Connecticut looked at that and had a task force on it. Deb, you've looked in Philadelphia about this business of, I'll put you on the spot. She'll be on this afternoon, but you and I had that discussion last night about are the tenants who are just tenants, they're not landlords, they're not getting compensated for the property. Where do they stand today in your judgment?
I love being put on the spot. I'll be up there later. So I'm going to show you that I did empirical research in Philadelphia. And there, the Redevelopment Authority was applying the federal relocation guidelines. And what I saw was for the majority, and this is not true for everyone, but the federal guidelines for tenants now, and this was not true in the 60s, generally seem to make tenants pretty happy. They got quite a bit of rent for the future. I don't remember the exact amount, several months, if not years, for where they were relocated to, or they got bumped up, or they got bumped up on public housing waiting lists, so they were able to get public housing, and they wouldn't have originally. So I guess that's all I have to say about tenants. But I also agree that businesses are the ones that do get undercompensated if you're talking about owners.
And like I said, there was a task force here in Connecticut that spent some time looking at that issue about compensation for the business value that they had. Other comments, questions back here? Oh, wait a second. Oh, go ahead. It's CONDOT, so it's okay.
Yes, I just want to, I think maybe my question wasn't understood correctly. I guess what I'm saying is I know the benefits. I know what residential tenants and businesses get. I know what they can get. The question I'm asking is the degree to which towns are focused on making sure whoever the consultant is truly applying the law to the degree that it should be so that they are getting the benefits. It's been my experience that that's not the case, especially when you're looking at a lesser educated population or impact area where people really just don't know. They don't have the resources to know. They are simply more inclined to be told to just do what they're told. You've got this long to relocate or to move. Here's how much money you get, and you're on your way. That's been what my experience has been with respect to people I've known that have been impacted by it. So again, I ask the degree to which towns are focused on making sure that the compliance aspect of the process is being held to.
Well, and let me add a footnote to that question, or a couple of them. What about the role of the ombudsman in empowering property owners? And what about attorney's fees? Who pays the attorney's fees for the property owners who are the object of an eminent domain action? It varies from state to state. We had a good conversation about it at dinner last night again. But could you answer this question and also see if you could sweep up some of these about, you know, civil Gideon, I guess we'd call it. Should property owners have a right to free counsel in an eminent domain case? Should they be compensated for their attorney's fees in the end so they can fight the government? What do you all think?
Those are complicated questions beyond my wheelhouse, but I know in Florida there is a constitutional right for attorneys in eminent domain actions, and they have a very different landscape of eminent domain law in the state of Florida as a result. I mean, I actually think it's an important point, and what the ombudsman is an interesting idea because I think a lot of times when we talk about the public use context, we really are talking about, we focus on the holdouts and the hold-ins, the people who are fighting, but that doesn't mean anyone who's negotiating in the shadow of eminent domain is affected by the threat of eminent domain. I mean, the fact that most people sell out doesn't tell us about what they're getting paid or whether they're getting a fair deal, because the government's essentially saying, look, if you don't take the deal, we're going to sue you, and you're going to lose your property anyway, and you'll have to pay for a lawyer, and you can't afford it. And unsophisticated people don't understand that system. So sometimes they may get more money than they deserve, but a lot of times they may get less, and the sophistication and wealth of the person who is bargaining in the shadow of eminent domain has to make a difference.
Oh, David?
Yeah, I mean, I certainly like the ombudsman concept. I mean, I think having someone within the government who is on the side of the public in this instance would probably.
Now, how would you feel if the people whose property you wanted to take had lawyers provided free to them, or when you were done, you had to pay their lawyers? Well, he has to leave now. He said he had to leave early.
Well, I was going to say, since we usually
question.
use state money for takings, no, you know, I think anything that makes the process certainly more fair, but first and foremost, at least seem more fair. I mean, a lot of the discussion today has been about just you know, people's perception when they engage with the government in this issue, and the intent is never to bully people or to have people walk away feeling that they didn't get what they deserve.
Professor Lamar, comments?
I mean, on the relocation question, the federal relocation guidelines come into play regardless of whether there's eminent domain if it's a federally funded project, right? And in the experience that I've had in New Haven on redevelopment projects, the business owners and tenants are quite aware of their rights, and that may be because we have an active legal aid organization that tends to represent them or what have you. The flip side of the business owner question is businesses that actually have wanted to move for quite some time and have never had the resources to do it, and now can, because they didn't want to be in this place that's now being redeveloped for new businesses. And they've been saying, yeah, I really wanted to move my X shop to the suburbs 30 years ago, 15 years ago, 5 years ago, and now I can, hallelujah. I don't, I'm not sure how up to date a lot of the empirics on some of these questions are old. They relate to, 1950s, 1960s era urban renewal. And, I think, for example, Debbie Beecher's book is great, that there's some new empirics happening. But I'm not sure that there's a blanket answer to your question, I guess would be the short on that, is that in some places tenants know their rights and others they don't.
Professor Maselli, you're all set. You're good. All right. Questions, comments? Oh, come on. Got 6, 7 minutes. What is this business of land assembly? None of you really spoke to it. I raised the issue. I've written a little, read a lot, and I have another student writing on it now. So does anybody want to describe for
I'll
folks
talk
here what private land assembly is, and whether you think it's any type of hybrid partial solution to the pain of eminent domain and the ability to confer assemblage value on people?
So we can talk about assembly distinctly from eminent domain. Eminent domain is just a tool to facilitate assembly, but that's separate from the question of, what is assembly, when is it desirable, when is it valuable? From an economic perspective, again, I have to qualify everything by saying that. It's a technological issue. That is, does the agglomeration of parcels, does the consolidation of parcels confer value? So in a situation where there are multiple individually owned parcels, as in the KELO case or any sort of residential neighborhood, the economic value would be the aggregation of those individual values. But that includes, by the way, not just market value, but any subjective value that the owners would attach to that. And so the question is, would the assembly of those into a single parcel that would facilitate a large-scale development like a factory or even a public use park or highway or whatever.
Or maybe a baseball stadium.
Or a baseball stadium, exactly. Would that increase value? Again, that is a separate question from the manner in which the assembly occurs. It could occur, theoretically, if markets function well, it could occur through individual transactions. That is, the developer, expecting a certain return, would be willing to pay individual owners their reservation prices and would acquire the land in that manner, and there would be a gain in value, and that would make everyone happy. That's the way the market would ideally work. The problem is that it doesn't work that way, because once some initial assembly occurs and people understand what's going on, that confers market power on those owners who have not yet sold, and they can then hold out not just for their reservation price, but for something on top of that. And if everyone adopts that strategic position, then you run into a situation where the assembly won't go forward, and we certainly see examples of that out there of highways to nowhere, that sort of thing. And that's when, to me, as an economist, there is a legitimate argument to be made for some kind of coercive. It's the same thing as using taxes or other kind of regulatory mechanisms to prevent externalities like pollution or to regulate monopoly. It's a way to overcome market failure.
And there are some private land assemblies, those of you may recall, across from West Farms Mall, so-called Astronaut Village, because streets are all named after astronauts. There was an attempt a few years ago for the neighbors to all get together, assemble their 1960s era split-level ranch subdivision, and then flip it out to a retail developer. It didn't happen. They couldn't get everybody together. And some of the land assembly systems, as I'm sure some of you know, in other countries, allow the government to still get the holdout, but really depend on private mechanisms to bring most of the assembly together and to confer the assemblage value on people, right? Is that a fair description of the system?
And I think the scale of the assemblage has a lot to do with the ultimate use and in kind of the current stage of urban design theory. I mean, I think, I would certainly argue that a lot of assemblages that were based on the assumption of, you need the whole block or you need the whole district result in developments that are less successful or less interesting because they remove the context whereby to be responsive to, right? In many instances, it's the assemblages that worked around a handful of existing buildings that feel far more organic and create more value in doing so. But again, it has to do with compatibility of land uses, right? You're not going to build a factory wrapped around one house.
Professor
I guess
Garnett,
so I totally agree. I think that the major Fort Trumbull style assemblages are not necessarily the ones that are likely to be most successful. And a lot of times you can build around the hold-ins and holdouts. There is some evidence that you can do some successful private assembly using secret land agents and other things. I had a student my first year who was a secret land agent for the Pokagon band of the Potawatomi Indians. I live on Pokagon Street. They were trying to get a reservation, and nobody wants a reservation, and that was her job. She went around secretly buying property. So I don't think we know, and I also don't think just because somebody wants to assemble something doesn't mean it should be assembled. I mean, there are good assemblies and bad assemblies. I think it's important to think about another thing which she raises, the sharing of the assembly bonus to the extent there is one. I mean, if the value of the property is increased dramatically and you're giving fair market value before the assembly, in some ways you're undercompensating people. And I know that plans try to take into the account of this by allowing returns and other things, but those tend to be, especially in big projects, targeted subsidies for a limited number of people, and there are winners and losers. So I think sharing the assembly bonus is a good idea. It's just a complicated one to execute.
Some sort of
Professor
shareholder
Lamar, you have
model.
you have some body language like you agree entirely.
Well, I don't know if, I do. I mean, I do agree that it's very hard. And it tends to be the people who hold out until the very end who somehow get incorporated into the plan because they have to be, and that's how you buy them off. But there's no reason why that has to be the case. And the Hockett mortgage plan is one where it's built into the plan that the bondholders have a right of first refusal. I mean, you could easily build into some of these plans, not just a right of return, but a right to profit.
Right. And of course, that the concept of fair market value, which is you were pointing out, Professor Maselli.
Well, the question is when you compute that. Do you compute that before the project is in the air, in which case all of the surplus will go to the assembler, or do you compute it after it has become known what the project will be, in which case the sellers will get a good share of it?
And some of us were talking about recently the fact that I think maybe most lawyers don't understand that value goes to the reasonable probability of a rezoning, not the existing zoning. And the uninformed property owner dealing without the benefit of good appraisers and lawyers is going to leave a lot of money on the table when they're done, which gets us back to the point of civil Gideon or attorney's fees and the like. But just in the last 4 minutes we have, I want to go back to planning because, Professor Garnett, that was quite an indictment. And I guess you didn't read my resume that I'm the past president of the American Institute of Certified Planners, but I get her point. In fact, the U.S. Supreme Court said in the KELO decision, it doesn't matter if the plan can't work and doesn't work. It just matters if they had kind of a belief that it might, if I can fairly characterize it as saying that. I think that's close. So anybody, how do we do the right planning? How do we do planning that makes sense for the government and is sensitive and makes sense for the property owners and the prospective developer, whoever she or he may be, now or in the future? We still have this going back and forth. What happens if you already have a developer or not have a developer? I mean, I get your point, but what are we going to do instead? Well, that's about all the time we have today. Thank you very much.
I know David has something to say about this, so I'll just tee him up and say whatever higher standard is that we place on these types of Fort Trumbull type redevelopments, I'm not sure they shouldn't also apply to highway planning. I mean, ultimately, all of these public uses are planned uses that somebody planned because they thought the plan would result in some kind of benefit. And some of the plans we don't question, and some of the plans we interrogate. Why do we interrogate the ones we do, I think, is the important question.
And some of them are clearly pretextual. I mean, we all have to acknowledge that in some cases,
absolutely.
right? Well, wait, careful, you're on the record here. So. Just as a lawyer, I want to warn you. you know.
Thank you, Dwayne. No, I mean, I've certainly, listen, I've been at public meetings where not a single person shows up, and the organizers are completely happy with that fact because it's less work for them to do. And then I've, personally organized 24-month participatory processes with a dozen meetings with hundreds of stakeholders involved that we had no idea what the outcome was going to be, and there was complete buy-in. And there's obviously good planning and there's bad planning, and I would be an advocate for good planning. I'd say within the context of this discussion, I'm happy that the courts aren't the ones that are dictating that, and I think it's up to voters to vote for elected leaders that are supporting good planning that actually is truly participatory and actually engages stakeholders. And I think it's up to all of us to educate the public that it is their role to hold elected officials' feet to the fire to ensure that they are being meaningfully engaged in the decision-making process.
So I'm I'm the land use planning professor that is a skeptic of planning. So I actually agree, and I hope I agree. I hope that you're right, that we've gotten better. It certainly seems to be infinitely better than the urban renewal period, right? But I just think we always have, my caution about whether it predicts success is that, history suggests it often doesn't. And so I like new urbanism better than, urban renewal a lot better. But I hope that in 20 years we're not all rolling our eyes about all these new urbanist developments that we've made, because that was the aesthetic of today and not tomorrow. And that's why I'm so worried about using eminent domain, because I think it freezes, it ossifies our plans once we start taking people's property to advance our plans. That was sort of the only point I was trying to make.
Well, that's all the time we have, and let's really send this panel off with the applause they deserve. They were just fabulous. Thank you so much.
Good afternoon.
Now listen up, please.
Good afternoon.
court days, we had come up with a plan basically to create an organization called the Castle Coalition, which we did with about $3 million in committed funding from our donors, and that the purpose of this new organization would be to try to make sure that what happened to our clients in London never happened to anybody else again. Not, by the way, an achievable goal, but we wanted to be as effective as we could through basically grassroots organizing and activism to prevent the use of eminent domain for economic development, because the Supreme Court had made it clear that the federal courts, at least, would no longer be in that business. There's an important line in the KELO decision where the majority says that, well, we're not going to interpret the public use provision of the U.S. Constitution as prohibiting economic development takings, but that doesn't mean that states have to follow that reasoning when interpreting analogous provisions in state constitutions. That turns out to be an important line because it, of course, gives state courts leeway to interpret their own constitutions differently. I'll get to that in just a moment. One other thing that we continued to do was file eminent domain cases in court, and we changed our focus from trying to win cases under the U.S. Constitution to trying to win cases under the state constitutions. And again, that's because of that line that well, not because of the line, but because of the opportunity that was acknowledged in that Supreme Court line, that you can still litigate these issues under state constitutions. I guess I'll stop. I want to pause here and say something that a lot of people who support the KELO decision try to suggest that perhaps it wasn't such a catastrophe because it left open the ability of states to decide on a state-by-state basis how much protection to provide for property rights. And I want to tell you, you won't be surprised to hear this, but I want to tell you anyway, that I emphatically reject that position as something we should take great comfort in. And I would ask you this: would we take great comfort in a Supreme Court decision that said that there is no such thing as free speech under the First Amendment and that should be decided on a case-by-case basis? Would we take great comfort in a Supreme Court decision that said that the criminal protections in the Bill of Rights don't apply, or at least can't be enforced in federal court, but you can litigate on a state-by-state basis whether police should be able to beat confessions out of suspects or compel people to testify in court, notwithstanding the language in the Fifth and Sixth Amendments? I think we wouldn't. And I know for sure that we wouldn't take comfort in a Supreme Court decision that had gone the other way in Brown v. Board of Education and said, well, there's nothing in the U.S. Constitution that speaks about racial segregation in classrooms, but if states want to decide on a state-by-state basis whether to permit that, they can certainly make that decision. We wouldn't take any comfort in those decisions. And I think that the suggestion that we take comfort in the Supreme Court's instruction that lower courts, state courts, could decide on a state-by-state basis how much protection to provide property rights reflects a similar mindset, or I should say reflects a mindset that in fact property rights are a second-class right. They are not as important as free speech. Property is not as important as racial equality. Property is not as important as the criminal protections in the Bill of Rights. I disagree with that. All rights are important, and property rights are not a second-class set of rights. But unfortunately, we lost that fight. The Supreme Court disagrees, and so we have been litigating state by state. Here's some really good news for those who don't like the Supreme Court's decision in KELO. With the exception of New York, every single state Supreme Court to look at the issue, i.e. whether taking for economic development is a public use, every state Supreme Court that has looked at that question under a state constitution has resoundingly rejected the U.S. Supreme Court's reasoning, again with the exception of the New York Court of Appeals, which embraced it. And that's good news because if you live in one of those states, that's Oklahoma, Ohio, and South Dakota, economic development taking is completely off the table because of court decisions. And there's another 4 or 5 states where it's virtually off the table, although the rejection of the reasoning in KELO hasn't been quite as unambiguous in those states. So that's the first part of the aftermath and the first change in the legal landscape is that there is a growing number, or I should say there are a growing number of state Supreme Court decisions that have effectively taken the kind of eminent domain taking that was used in KELO off the table. And of course, I think that's very good news. Oh, and I should add Michigan to that. As Wes told us earlier, Michigan actually got to that result in a case called Hathcock before the KELO decision even came down. So there's a number of states where you're protected. Perhaps even more consequential was the reaction of state legislatures. As I mentioned during my original talk, KELO is, bar none, the most reviled decision in modern history, and one of the most reviled Supreme Court decisions of all time among members of the public. And not only federal legislators were quick to condemn the decision, as I mentioned during my talk, but states were as well. And so actually at this point there are 47 of 50 states have passed some kind of legislation, and in some cases actually amended state constitutions to tighten up eminent domain laws, to make it more difficult to use eminent domain. I won't try to do, excuse me, an exact head count, but basically those responses fall into three categories. Very strong responses that have had significant or appear to have significant effects. For example, in Florida, which was one of the worst abusers of eminent domain, they took blight-related eminent domain off the table. I'll explain in a moment why that matters, because the use of essentially the argument that if an area is blighted, you can use eminent domain was horribly abused in many states. I mean, disgracefully abused. Taking neighborhoods that weren't remotely blighted, hiring a survey company with the specific purpose of finding to the contrary that they were blighted, and then using the power to remediate blighted neighborhoods when in fact they weren't blighted at all. So taking blight off the table is a huge change, and they did that in Florida. And Florida went from one of being the worst abusers of eminent domain in the country to not using it very much at all, I think in large measure because of that statutory change. About a third of the states had medium to weak responses where there's some change that makes a little bit of a difference. So, and the major ones we're talking about here, redefining public use, changing the burden of proof, tightening the standards in other ways. These are medium responses. About maybe a third of the states did that. And then and these are not precise quantities, but maybe another third of those 47 states, the changes were complete window dressing, absolutely meaningless. Delaware is an example of that. They changed their law to say that from now on, the only eminent domain takings in Delaware would have to be for a public use, which was already the law. And public use had already been defined by the Supreme Court in KELO as meaning essentially anything. So that's window dressing and it's meaningless. And there were a handful of states that obviously did nothing because only 47 states, or I should say there were 3 states remaining, Connecticut being one of them, and New York, I believe California, California made some changes. Anyway, so those are the statutory changes. And the third result that I think is really important to keep in mind is the change in public perception. As I mentioned before in my earlier talk, the KELO case really in some ways did take an obscure 13-letter term, eminent domain, and turn it into a 4-letter word. If it gets out that your project is considering using eminent domain, if you're a local government, and that term comes up, that can just poison the well right there. We have poisoned several of those wells, and I say that proudly. Most recently, we did that a few weeks ago in Charlestown, Indiana. There was a neighborhood, which I wrote down, and now I can't find it on my notes, but there's a neighborhood in Charleston, Indiana, that's basically a group of World War II era homes that are lived in by people of relatively low income. There are 354 homes, and the city council and the mayor of Charlestown, Indiana, proposed to just bulldoze all of them, almost identical to what happened in the KELO case. We got involved, and once we publicized the fact that they were going to use eminent domain to achieve that result, everybody except for the mayor began scuttling away from that program as fast as they could back up. Only the mayor remained committed to it. And then at a rather raucous city council meeting a few weeks ago, the mayor was completely defeated by the city council, and the project is over. It's not going to happen, or at least it's not going to use eminent domain. So I think it's important not to underestimate any of these components and not to suppose that one component explains everything. In other words, it's not just that some courts have taken eminent domain off the table. It's not just that some states have tightened up their statutes and or constitutions, and it's not just that public opinion is now very strongly against the use of eminent domain. And by the way, it does remain strongly against the use of eminent domain for economic development takings. I think it's all of those things together, and it varies depending on the jurisdiction. I'll tell you a couple of lawyers like to tell stories about their cases. I do. And I'll tell you a couple of stories that are really evocative for me. We had 2 cases in Ohio right after the KELO decision. They were both state constitutional cases. One was in Lakewood, Ohio. The other was in Norwood, Ohio. And they illustrate different parts of the post-KELO dynamics that I've just described. The first one, excuse me, was the case Norwood. And it was basically a KELO-style taking. They wanted to just bulldoze the neighborhood and build Yuppieville, crate and barrel with apartments on top of it, if I recall correctly. And The defining moment in some ways of that case was when we got to the Ohio Supreme Court, and everybody knew that this was coming down to the question of whether the Ohio Supreme Court was going to follow or reject the Supreme Court's analysis in KELO when applying an analogous provision of the Ohio Constitution. And during the city attorney's argument, when he was defending the plan and the use of eminent domain, he made the following statement. Your Honors, this court basically should not get involved because the city planners, the people who run the city of Norwood, know better what is the best way to use this land. And one of the justices looked at me and said, I would think, actually it was she said, I would think that the owners of the property know the best use for the property. And the courtroom erupted in applause. It erupted in applause. And I've never seen this before. The presiding judge picked up his gavel and basically went like this, tap, tap. I know this is a very charged case, and if we could just wait until afterwards to, basically express ourselves. And then the argument went on. And in a record short time, we won that case unanimously in the Ohio Supreme Court. They wanted nothing to do with the Supreme Court's analysis in KELO. And as I said, that's been the trend in every single state Supreme Court to look at the issue, except for the New York Court of Appeals. The other story I wanted to tell you comes from, not from the court, but from the Court of Public Opinion. We have a media department at the Institute for Justice run by a guy named John Kramer, and John had the brilliant idea one day of picking up the phone and calling 60 Minutes. He just cold called 60 Minutes, got a producer on the line and said, I know you're busy, can you give me 30 seconds to pitch a story to you? And he pitched eminent domain, specifically eminent domain in Lakewood, Ohio, which is where we had the other case going. Long story short, they took a little convincing, but once they got the bit in their mouths, they ran with it, they loved the story. And the takeaway, and they did a story on it. It's a wonderful story on, well, if you hate eminent domain, it's a wonderful story on eminent domain. But they did a wonderful story where they really looked very deeply into the taking in Lakewood. And the taking in Lakewood was what I just described earlier. They couldn't take it for economic development. They had to use blight. So they had to essentially get the court to hold that the area was blighted. The problem was it wasn't blighted. It was just a regular residential neighborhood in Lakewood, Ohio, and actually it was really pretty. Bunch of little single-family homes by a river, but they wanted to bulldoze those homes and again sort of build Yuppieville. And we were able to provide information at 60 Minutes that Mike Wallace used incredibly effective. It was one of the most effective on-camera cross-examinations that I've ever seen. This is, I'll end with this. This is Mike Wallace's conversation with the mayor of Lakewood, Ohio. He looked at her and he said, so according to the parameters that you've used to determine whether a home is blighted, if it doesn't have central air conditioning, it's blighted. Does your house have central air conditioning? And she said, she got a wry smile, she knew where he was going. She said, no. And he said, blight! If it doesn't have an attached garage, it's blighted. Does your house have an attached garage? Blight, you see where this is going. Well, it turned out that the homes of every single city council member and the mayor of Lakewood, Ohio were blighted, according to the terms that they used and that they tried to use on this neighborhood. That's the kind of disingenuousness, unfortunately, that comes when you don't have significant judicial review. We don't have that from the U.S. Supreme Court, but the good news is we're getting it pretty consistently from state Supreme Courts, and that's all to the good. Thank you.
Next up we have Tim Hollister, who's a partner at Shipman & Goodwin, sponsored our diversity. Tim practices land use, environmental, and municipal law. He handles real estate and administrative matters, and he's argued more than 30 cases before state and federal appellate courts. Now today, he's going to be talking about changes in Connecticut law and his experience litigating the Connecticut Supreme Court case post-Kelo. I'll turn it over.
Thank you. Honored to be here. Nice to see you all. So I had a potentially historic but ultimately a tiny little role in the Kelo case that I want to start with. So in New London, and Clark confirmed me, the redevelopment area, 99 acres, you get to that acreage by going under a railroad bridge. And in the early 2000s, if you went under that railroad bridge, on the left and on the right was a junkyard owned by a Mr. Calamari. To get the redevelopment underway, the New London Development Corporation, flush with state money, needed that property, and they needed it ASAP. So my partner, Alan Lieberman, and I represented Mr. Calamari. So, of course, when you represent a landowner, there's nothing quite like an anxious buyer who's not only well-funded, but publicly funded. And we got Mr. Calamari a very nice, I will say, more than just compensation package, whereupon he then, probably in his early 40s, retired to Florida, and the New London Development Corporation had the first piece of its economic plan. But I will, of course, wonder for the rest of my days whether if Mr. Calamari had held out for more money, he would have replaced Mrs. KELO, and I would have had my place in American legal history. So, not getting that place, I actually had a little bit of a bonus prize. Being a member of the U.S. Supreme Court Bar, I attended the oral argument, and I got the seat right behind the podium. If Wes Horton and Scott Bullock had taken 2 steps back, they would have been in my lap. It was quite a vantage point for the argument. So anyway, so then I ended up advising being one of many advisors, but one of the advisors to the Connecticut General Assembly when they were looking in 2005, 2006 at amendments to the eminent domain law. And then, as some of you know, back in 2012, I sort of stirred the pot a little bit with an op-ed piece in the Connecticut Law Tribune where I wondered whether Mrs. KELO's house might have been saved based on a state law claim of necessity, a separate constitutional analysis, much along the lines that Clark was suggesting. So anyway, to trace how KELO has changed eminent domain practice in Connecticut, let me start with how I, as a land use litigator, approach these eminent domain cases. And the starting point is there are 6 potential ways to challenge City Hall when they initiate what the courts call the awesome power of eminent domain. Number 1 is you try to find a procedural error in the taking process, in their condemnation steps. Number 2, and this comes up more than you would think, you have to ask whether the condemning entity actually has the power of eminent domain. I bet David Domina has some cases with that, but particularly where it involves a utility or a quasi-public agency. Third, obviously, is that the taking is not for public use or a public purpose. Fourth is where there's a taking of more land than is necessary for the stated public purpose. And then another claim is the taking is in bad faith. And here in Connecticut, we actually had a case that I was involved in called New England Estates versus Branford, a 1983 federal civil rights case based on the town of Branford claiming that it had condemned land that was proposed for affordable housing because their own landfill had contaminated the property, which turned out to be, let's just say, not true. And the Connecticut Supreme Court called them on it and said that their actions were dishonest, and there's a whole financial side of the case that I won't go into, but there are actually such things as bad faith claims in takings cases. And then the 6th is, if the taking goes forward, is the appeal of just compensation. Now, so add on to those what I call the 3 Connecticut caveats. The first is that our state constitution has its own eminent domain provision, so you'll always want to be looking at a separate state constitutional analysis as to whether Connecticut will be more protective of the property owner than the federal constitution. Second, in Connecticut, remember that I think this is true in most states, but takings procedures are strictly construed against the condemning authority. And third, Connecticut allows remediation costs to be deducted from just compensation on a dollar-for-dollar basis. So then we get into what I call the red flags of condemnation. The condemning authority is not a governmental agency. Private party pays some or all of the just compensation. The primary beneficiary of the eminent domain is a private entity whose finances are not open to public inspection. Condemnation is for economic development where there's a study basically funded by the condemning authority, which is a very easy standard. The condemning authority, the condemnation is for use that will be privately operated. The condemnation is for, it will violate potentially a state or federal civil rights law such as the Fair Housing Act, And then finally, again, sort of echoing what Clark says, the definition of blight is being stretched beyond all reasonable meaning. So with that background, I would say that the KELO case has had 3 impacts in Connecticut. Number one is that due to the extensive procedural amendments in 2007, which I'll describe in a moment, procedural compliance is now a very complicated process with all sorts of traps for the unwary. Number two is with KELO blessing economic development as a public use, you need to use this state constitutional analysis. And number three, and this is in general all across the country, eminent domain has become this political third rail, so only to be used as a last resort for politically acceptable as opposed to municipally necessary situations. So before I turn to the actual amendments to the Connecticut statutes, let me say this about the process in Connecticut for eminent domain before the amendments. Eminent domain is a general power of a municipality under 7-148 of the Connecticut statutes. But the procedures are very complicated. It starts in Title 48, which then directs you back to what is known as the redevelopment agency statutes, which start at 8-127. So historically, this is before 2007, in order to read and understand the procedures in Connecticut for eminent domain, you had to read a statute and substitute municipality for redevelopment agency. And the problem has always been that the redevelopment agencies and municipalities are different entities. They have different standards and different procedures, and they don't always line up. So that was the procedural mess that we had before the 2000 amendments. But because there was so much eminent domain case law embedded in the redevelopment statutes, the legislature didn't really have the option to start over and try to make some sense out of this mess, so they added on all these new procedural provisions to the existing mess, and so that's where we are today, and why I say it's complicated and there's all sorts of traps for the unwary. So let me, with that background, let me run through and I've sort of oversimplified this. Here are the main amendments that Connecticut adopted in 2007. Number one is they removed from the general municipal powers the ability to use eminent domain, quote, to encourage private economic development. Just took that out of the statute completely. For municipal economic development and redevelopment projects, number one, real property cannot be taken for, quote, the primary purpose of increasing local tax revenue, unquote. The condemning agency must conduct a public hearing. Any taking requires ultimately a 2/3 vote of the legislative body of the municipality. That body must take a separate vote on each and every parcel that is to be taken, which I guess would be the assessor's parcel. They have to adopt a resolution. They have carefully weighed the costs and the benefits of condemning versus not condemning. They have 5 years, sort of a sunset provision, to vest title, which they can extend with a separate vote to 10 years, but if it goes beyond 10 years, then they have to start over again. And finally, if the land is not used for its condemned purpose, it has to be offered back to either the owner, the original owner, or the heirs of that owner. Redevelopment plans and this is based on a case in Stamford that proceeded on the basis of a 30-year-old economic development plan. Redevelopment plans are only valid for 10 years. And then we get into some of the nitty-gritty procedures. 2 appraisals are now required as a result of the 2007 amendments, and each appraiser has to give a copy to the landowner before the town initiates the eminent domain, and compensation has to be the average of those 2 appraisals. If the taking is a municipal economic development as opposed to redevelopment, which is again where some of the confusion comes from, if it's a municipal economic development, then the compensation paid must be 125% of fair market value. They also lengthened from 12 to 35 days the minimum time between the filing of a notice of condemnation and the issuance of a certificate that creates the vesting of title, eliminating the so-called quick take provisions. And then they expressly codified that, and this was common law, that a condemnee can bring an injunction action to stop the eminent domain from proceeding. So it's interesting to note that the amendments establish a potentially whopping economic difference based on whether it's a redevelopment or development project, 100 versus 125%, and it requires the court to make a determination as to whether there is a primary revenue purpose, increasing local tax revenue, and whether the taking is a redevelopment or development project. So again, the well-intentioned amendments, but made it very complicated to work through. So let me end with my involvement more recently in a case called Emery versus City of Middletown. I believe it's the only case to be litigated involving these amendments. So Mr. and Mrs. Emery owned a property in Middletown's north end. It was called 12 Clinton Avenue. It was a two-family residence on 1/3 of an acre, and it had a fenced rear yard in the back that was about 2/10 of an acre. So, and the Emrys also, if you know the north end of Middletown, the Emrys also owned what's called the trolley barn, which is the big commercial structure. If you come off the Aragoni Bridge, it's right there in front of you. It's where Middletown used to store the trolleys overnight when trolleys ran down and back and forth down the middle of Main Street. Well, a new community health center was built along Main Street, and the rear of that building had a parking lot that was undersized for the new building, and that parking lot adjoined the back of the Emery's property. So basically, the CEO of the health center got together with the mayor and the town planner and said, we need the back of that Clinton Avenue property for more parking. So we found in discovery an internal memo where the city officials justified the taking on a revenue basis. They said, well, if we get 59 parking spaces, we can collect $60 per space per month. That's $42,000 a year. That will support $475,000 in acquisition costs. 30 of those 59 spaces would have been on the Emery property. So the city got two appraisals that did not use, even though that was their internal justification, that did not use the income approach to valuation. They valued it based on a square footage of comparable vacant commercial land in the city of Middletown. They also did not do a parking utilization study indicating the need. And so when the city moved forward, I was hired and we made the following claims. And this will sort of tie together what I was saying earlier. Number one is that we figured out that they had not transmitted the appraisals in advance of the taking, so that was one procedural error. Number one, it was clearly for local revenue generation in violation of the statutes. Number three, it was the taking was economic development requiring 125% compensation, and they'd only tendered 100%. There was no parking study, so there was no demonstration of need. And I also claimed that the appraisals, since they didn't use the income approach, were a bad faith use of the condemnation power. And there was also an untimely notice claim. And Judge Domnarski enjoined the condemnation, reaching only the issue that the city had not provided the two appraisals in a timely manner, and probably wiping his brow with relief did not reach the other issues. But at that point, the city backed down. So I think it just goes to show that as well-intentioned as these amendments were, they created a minefield that even a somewhat sophisticated town like Middletown, which has a great legal and planning staff, was not able to navigate. So query what happens the next time somebody tries to do something along these lines. Thank you.
Turn my microphone on there. Thank you, Attorney Hollister. And we have our arrival from DC. Welcome, David. And I hope are you ready to go?
I am all set.
Word came from down the panel that you were ready to go. So we'll actually step back in between our two state litigators' talks to hear about the broad overview. Mr. Parkhurst will discuss KELO and the changes from his perspective, from the perspective of the National Governors Association, where he serves as counsel. Prior to that, he was counsel to the National League of Cities and the National Association of Insurance Commissioners, which is near and dear to our hearts here in Hartford. I'm sure you traveled up here. You took that flight many a time. And he's also worked in private practice. So you're welcome to stay seated. You're welcome to come up here, whichever is easier for you.
Nothing like a dramatic entrance.
Thank you.
and I'm glad to be standing up since I've been sitting on an airplane for the last 3.5 hours. To let you all know, the storm from Baltimore is heading north. So, again, I appreciate the opportunity to be here today. David Parkhurst. I am General Counsel of the National Governors Association, but apparently UConn was able to discover my deep, dark past. I was counsel at the time in 2005 for the National League of Cities. National League of Cities is the largest and oldest national organization representing local governments including council members as well as the executive branch of mayors from across the country, including one of our longstanding members is the Connecticut Conference of Municipalities, which, as you know, was one of the amici on behalf of the City of New London. My role back with the National League of Cities was to serve as the appellate coordinator and filer of briefs that would affect federalism and preemption that would have an impact on municipalities. KELO fit the bill. The opportunity that I had here was more of a bit player on the large stage of a large Supreme Court case. The good news was I was still on the stage, and I have a great, just some stories here of some of the experiences that led to. Again, as I said, I was involved in coordinating the amici on behalf of the city. I was working with Wes Horton and his legal team. We actually put together some moot courts at Georgetown in advance of the oral at the Supreme Court. But I think that the surprising role that I played in KELO was the post decision in legislative, political, and the communications angle of this case, which I think really from the two observations I'd like to make today, first and foremost, while state and local governments may have won at the Supreme Court, we definitely lost in the court of public opinion. We were hammered in the court of public opinion, and it took us by surprise. Second of all, I would argue that politicians at all levels of government, post-Kelo, tended to overshoot a little bit, I think, in their rush to judgment on the impact of the case and its strategic importance going forward. And I just wanted to jump into that a little briefly and talk about how we, at the local level, may have won at the court level, but we lost in the court of public opinion. Again, as I said, I represented local elected officials. For those of you that have represented locals or are yourselves local elected officials, you know that municipalities have limited authority generally, and some of the areas of their strongest authority are in land use, zoning, and economic development. And this case was about separation of powers, and it was about preemption for local elected officials. And that was a driving force in having the National League of Cities try to rally our respective national organizations of state and locals together to file an amicus brief. Now, I'm happy to report that of these 7 national organizations representing state and local, I was successful. We got 6 of them to join. The one holdout is my current employer, the National Governors Association. Interestingly enough, the backstory, as I found out after joining the good governors, was that at the time, the chair of the organization, a Western governor, a lawyer by training, looked at the case, listened to the arguments, and said, "It's a strong case here. This is good, but governors will not participate in this one." I think that was a foreshadowing of what was to come. And while many of my brethren were pleased to have the League of Cities at the forefront of this, I think they were the early adopters of the lead by behind motif. I think that at the end of all of this, the lessons that we went through, going through hard times, obviously makes you stronger. And I think from a local perspective, that was a good experience. As you probably have heard, again, I would argue that legally, the decision itself was unremarkable. It really reaffirmed years of precedent that eminent domain for economic development is a public use under the Takings Clause. And in fact, I think there's a strong argument to be made, and I hope that it was made earlier today, that when you look at the opinion by Justice Stevens and the concurrence by Justice Kennedy, it actually probably made it a little harder going forward legally for local elected officials to execute eminent domain going forward. I think that what we see in the Kennedy concurrence lays out a roadmap. Maybe not as clearly defined as Justice O'Connor would have liked, but I think it does lay out some touch points for local elected officials and state officials to apply when they are pursuing eminent domain for economic development purposes. What are those? A transparent process, need for identifiable public benefits, and making certain that you don't have any identifiable private parties at the start of this effort. You want that a reasonable promise of promised results from the economic development are likely to happen, and that finally that you want to have some evident need, that there is a public need for the redevelopment. So I think that that framework is something that is a tremendous benefit of the opinion going forward and the decision's application. Now, as I said, I think that post-Kelo, we were really caught off guard. I remember being at the oral arguments. We had Mayor Williams of Washington, D.C. at the time, who was the NLC president that year. We had a press conference on the steps of the Supreme Court after the oral argument occurred. It was, again, unremarkable, a few handful of press. I think some of the traditional Linda Greenhouse and some of the traditional court media were in attendance. But I think that after the after we finished that presser, we go back, I think that the sense was, okay, let's just see what happens in June. And we went about our merry way. We went about our business. We did not plan for any other contingency. Fast forward to June, the opinion comes out. Within hours, Fox News, Cox Broadcast, McClatchy, USA Today were calling our media office at NLC and asking for comments, opportunities for my executive director at the time to go on various nightly news shows. What he couldn't do, I ended up having to do. We were in a firestorm for that period of time. And I remember getting an email from a former colleague of mine who sent I would label it an internet screed of what was being talked about at the time, and I was able in this preparation process to pull out the file and read what I wrote, and it was interesting. I looked at it, and my comments to Carol were, the media is missing the point here. This is signaling to states and locals that they've got to tighten up how they apply eminent domain. This is going to become a legislative issue. So moving forward, I think that's what we saw. Now, how did the League of Cities, how did we talk about Kelo post-opinion? It was never boastful. It was never, we won, start the bulldozers, grandma watch out. That was never how it was approached. In fact, how we approached it was an opportunity for the local officials really to reframe the issue of eminent domain as a public policy tools. Again, as we said, state and local elected officials generally, I'm making a broad generalization here, but from my experience, 20 plus years working for state and local elected officials, they generally use eminent domain prudently, responsibly, and as a last resort in many cases. And those that don't face blowback in the press, the courts, and the election box, the ballot box. And I think that was an important point that we tried to move forward going into post-Kelo. Now, how have laws changed post-Kelo? Well, what did Congress do? As I said, once the opinion came out, I was moved into a different role. I moved into legislative role, which is another hat that I do wear with the League of Cities as well with the governors. Again, I think Congress did what Congress does best, and that's, again, a rush to judgment, rush to the media, a rush to the microphones. Though I think it was important to note that more people lost their homes to natural disasters in 2005 than they did to eminent domain. Now, the first 6 to 9 months, there were tremendous efforts in Congress to overturn the Kelo decision. You may remember them. I want to highlight a few in particular. One, Mr. Sensenbrenner from Wisconsin. I believe at that point he was either chair or ranking of the Judiciary Committee. I remember he famously put forward legislation that would prohibit the use of all federal funds to any state and locality that used eminent domain for economic development purposes. That's education money, that's Medicaid money, that's housing money, that's CHIP money. All federal funds would be wiped out. I think the results of that, fortunately, we were able to chill that movement. But what we were unable to do was to stop the use of the appropriations process to legislate. And for those of you in legislative practice or legislators yourself, you know that one of the rules of thumb is you really shouldn't use the appropriations to legislate, even though that's what appropriators do. And that's what happened here. Senator Bond of Missouri, the chair at the time of the subcommittee for transportation, Treasury, and HUD, we affectionately call that the THUD bill in Washington, actually was successful in negotiating an amendment. And I remember working on this with his staff and his appropriations team for many, many weeks and many nights on trying to narrow the bands on what would be the federal limitations going forward on the use of federal funds. And what we ended up settling on was, in this case, for the FY06 appropriations bill, read it properly here, federal funds may be used for any economic development project that exercises eminent domain for a non-public use, except for transportation and blight removal. Subjective in its interpretation, provides some exceptions for blight, which KELO didn't address, for transportation, the traditional uses of public use, and the Bond Amendment passed. Now, rule number 2 in not legislating on appropriations bill is that when you do and you are successful, they take on a life of their own. And as far as I know, I think that the Bond Amendment is still in force. It simply gets renewed annually. And after about 8 years now, I think that we've had enough turnover in Congress that, they probably don't remember who Senator Bond is, let alone what his amendment was about. So I would believe that it may still be in place here. Now, what did the states do? Again, I think that the states were directed by the opinion on what to do, and that was eminent domain, state-based law. The states are where the action should occur, and that's where it did happen. And I think another key message here that I would deliver is that the action really happened within the 2 to 3 years immediately preceding the opinion. Post-2008, very little has happened. In fact, the only state that has addressed eminent domain legislatively and actually made a constitutional change to the state constitution was the state of Virginia. That was completed in the 2012 election cycle after I think it was a two-pronged process where the state required that the two sitting legislatures adopt the legislation before it was put to public referendum, and it was adopted in 2012. And as best I can recall, I think that was the last bill that has come to light and to enactment on eminent domain. 3 policy buckets. And again, I apologize if I'm repeating what some of my colleagues may have already discussed here, but I think there were really 3 policy buckets that state and municipal law fell into as a response to the KELO decision. One was the prohibition and limitation bucket, thou shalt not. Again, some of that thou shalt was couched in subjective language that allowed for a little room for interpretation. Primarily, solely, predominantly were descriptors used in much language there. But again, it's prohibition of the use of eminent domain for economic development purposes, to generate tax revenue for a municipality or for a state, or to grow jobs, to increase economic growth. Those were the prohibitions. I think it really tied back to Justice O'Connor's reference to Calder v. Bull and the A to B transfers. And again, nobody was in favor of an A to B transfer of eminent domain across the board, and definitely from the NLC perspective, that was never a position that we took. I think the second bucket was definitional. You had about 12 to 13 states that redefined what public use meant. They redefined blight as to a detriment on public health and safety. They tried to narrow the parameters a bit around that. And the third bucket was process. And I thought, personally, this was an area of opportunity for innovation. I think it's clear from the record in the case that the City of New London did a pretty good job of process. 6 various plans that the aldermen went through before they settled on the final Fort Trumbull plan. Public comments, public hearings, a very open process, public notice and hearings. These are some of the process elements that many states adopted, together with requiring good faith negotiations with landowners, particularly residential landowners that were facing an eminent domain challenge, and final plan approval by an elected public body. Again, tying back to the importance of the ballot box as a checkpoint on decisions at the state and local level. Now, I'd say, what did the locals do? And the locals themselves were very active post-opinion. And we at NLC at the time conducted a post-Kelo survey. The survey showed that about 3/4 of those surveyed local elected officials said that they had not exercised their powers of eminent domain in their municipalities in the preceding years leading up to the decision. However, 87% of local elected respondents said that the opinion would not basically would not delay any pending economic development projects because of the decision. So again, I think that the locals, while taking the opinion very, very seriously and taking it as an opportunity to reframe the conversation, were not paralyzed in this powerful tool that they did have at their disposal, that they do have, and that they do use at their disposal. I was struck in particular at the time, one of the leaders of the National League of Cities at the time was a mayor from Colorado, Lakewood, Colorado. Mayor Burkholder wrote a letter to the Colorado congressional delegation, and I found it, and I thought he summed it up nicely of the importance of eminent domain, and he described it as a critical tool because cities never stay the same. They either become a better place to live or they begin to decay. And I think that was a nice summation of where local elected officials were with the KELO decision. So let me bring it to a close here. The anxiety that people feel about eminent domain, it's real. It centers on a fundamental issue that is personal to all of us: property, freedom, our home, and our community. No wonder people are as passionate as they are about this issue because of its fundamental elements to each and every one of us. Historically, there have been elements of governmental abuse in eminent domain. I think we can look back to urban renewal. We can look at the construction of the interstate highway system. We can look at other areas where the public does have a base of evidence to draw their concern. But I think this history also imposes on elected officials at the state and local level an opportunity to explain with greater sensitivity, because of the personal impact, why government would use eminent domain. I think 10 years after KELO, that's still a responsibility for state and local elected officials. At the same time, it's a very delicate balancing act that has to be played between minimizing the burdens on individuals while at the same time maximizing the benefits to all of our communities, including New London. Thank you.
Okay, so finally we have Attorney David Domina, who is the principal of Domina Law Group based in Omaha, Nebraska, which he founded in 1982. He has a wide range of experience, including criminal capital cases, as well as the claim to fame of being one of a handful of attorneys who's ever received a billion-dollar plus jury verdict. So that's pretty interesting. But today he's going to speak on his experience litigating against a post-Kelo Nebraska law that makes it perhaps easier to take land to build the Keystone Pipeline.
I'm going to try it from here. Can you hear me from here? Yes? And I'm going to watch you in the blue shirt. You've had the worst seat in the whole place. If you nod off, I'm going to step it up. So I want to start with this. How many of you have been to Nebraska? All right. I was tempted to ask how many of you have been to China, thinking that might be a close contest. So Nebraska is 14 times the size of Connecticut in surface area. It has half as many people, and it has half as many houses in the state legislature. We have a unicameral, nonpartisan legislature. Most of the people who run for public office in Nebraska run as nonpartisans. The governor doesn't, the attorney general doesn't, a couple of other constitutional officers don't, mayors don't, but pretty much everybody else, including the members of the legislature, do. In the 50s and early 60s, mid-60s, we built about 650 miles of interstate highway across Nebraska, and we had 10 eminent domain cases. We have 100% public power in our state, no shareholder-owned power. We have lots and lots of transmission lines, and annually we have about 2, maybe 3 eminent domain cases. We have 52 pipelines built across the state, and those pipelines in the course of our state's history have generated about a dozen eminent domain cases. So I was quietly practicing law in my corn and cattle practice out on the prairie one day when a farmer client of mine called me from Boyd County, which is up on the South Dakota border, and he said, "Dave, who the hell is TransCanada?" And I responded, there is a clicker here someplace, you gave it to me, thank you, essentially by saying, in response to his question, "I don't know, never heard of them." And that was true. TransCanada in 2010 had come early to Dave Fisher's home and said to him, "If you don't sign this easement, we're taking you to court as early as next month to take an easement across your combination farm and ranch land." Now, Boyd County, Nebraska, has a total population of 950 people in the county. It's adjacent to Holt County, Nebraska, which has become the bellwether holdout county against the pipeline in the United States of America, and its population is about 4,000. And on across the state, counties, we have 93 of them. We should have had 7, but we have 93, and of those 93, 15 have populations of under 500 people. Now, we didn't know much about this pipeline or this pipeline company when we started out, but we were interested in finding out. And so we found out pretty quickly that people weren't very happy with TransCanada or with its plans, not because they were environmentalists, not because they didn't like the company initially, but because they were bullies. You heard the 4 objectives of KELO from the last speaker. None of those were present in what TransCanada did. Our citizens, to the extent that they had any experience with pipelines, were familiar with companies that came out 4 or 5 years in advance, spoke to them softly, explained the project, talked about the easement, and above all, assured them of 2 things. Number 1, if we have a spill, we clean it up at our expense. And number 2, when we're finished, we will take that pipe out of the ground and we will put your property back and it will be yours again. We'll be here in the meantime. This outfit came to Nebraska and said, number 1, we want to build a pipeline with a 50-year life. We want to take a permanent easement. Number 2, we want to pay you once. We're going to make more money on that land of yours than you'll make in a decade, maybe longer. We're going to pay you once. Number 3, our easement's non-negotiable, and it contains a provision that says if there's a spill, we've got to clean it up, but we'll fight you for who's at fault. And number 4, the easement expressly provides that the pipeline remains in the ground at the expiration of its use, and TransCanada keeps the easement for whatever it wants. Now, this pipeline didn't go through anybody's front yard. It goes within 100 feet of a few domestic wells. It separates irrigation wells from center pivot irrigation systems, very important to a lot of Nebraskans. It separates points of entry into huge cattle ranches, extremely important in the fragile sand hills, and it runs over, and I'm sort of behind myself, but we'll get there, the world's largest aquifer. I'll show you that in a moment. TransCanada was out with landmen, offering nominal payment in terrible terms. So there was an uproar, and our legislature had almost no history of having visited this area. We had a little one-sentence statute that suggested maybe a pipeline company maybe had the right to take land if it had to, but virtually no history of it ever being used and no terms. So in 2011, our unicameral legislature met in an extraordinarily rare single-purpose special session for the purpose of addressing the absence of any siting law for pipelines. I sensed a need to help the legislature. And in my little prairie state, you know, one lawyer can get to have kind of a reputation whether you want it or not. And I sort of am stuck with that, whether I want it or not. And so I was getting calls from the members of the legislature saying, we're not asking the Attorney General, what do you think? What can we do? So I wrote something I called a green paper and attempted to outline for them, as a corn and cattle lawyer, what it is that eminent domain really is. And I said to them, first of all, you start with the idea that eminent domain is something that effectively precedes sovereignty. And by that what I mean is you can't have a government that can function unless it has the power to acquire those things it essentially needs to function, like to build a road or to provide for fundamental and essential services of government. Secondly, the power of eminent domain is an exclusively legislative power. You, legislature, do not have to give it to a city, you don't have to give it to a county, you don't have to give it to anybody else, but you have to control who gets it and on what terms, and you have to abide by the constitutional requirements, the same in Nebraska as in the Fifth Amendment, that the purpose be public. The legislature met. It passed a couple of reasonably good laws that were never attacked. TransCanada was blindsided. So it met again in 2012 in a general session, and then Nebraska learned what job creation means. The lobbyists came to the state. And we found out that TransCanada was willing to spend more money on the Nebraska legislature than anybody had ever spent in a single session of the legislature on all of the issues before the legislature, and they did it on one. And they got passed a bill called LB 1161. It's worthwhile to know how they did it. LB 1161 was an innocuous little thing that went through the Natural Resources Committee. When it got to the floor, it was gutted. All of it but the title. There was an amendment substituted on a Tuesday. It was passed on first reading and passed on final reading on the same morning on Thursday. The Speaker of the legislature, who had handled the special session and masterminded those laws, if you will, who happened to be my son's childhood friend, voted against it and tried to get it stopped. It passed. Now that happened in 2012 in April. In 2011, when our legislature met, candidates were still sorting themselves out for the 2012 presidential election. But by April of 2012, when the legislature finally got around to passing this law, the Iowa caucuses had occurred, but not too long ago. The New Hampshire primary had occurred, but not too long ago. And so had one of the primaries, maybe two in the South. And one of the candidates for president, who I understand lived nearby here, had already said that he was prepared to dig the trench for the pipeline with his bare hands, which most of my clients would have liked to have seen. They were laying bets on how long it would be before he developed a callus. So that law passed. A month later, we filed a lawsuit. We offered the case to the Nebraska Supreme Court as an original action. It declined to take it. We thought maybe TransCanada would perceive the need to get the legal issues decided in a hurry and support that. They didn't. So we filed the case in district court. The press at the time was telling Nebraskans, look, it's a big, stable company. But the Nebraska Supreme Court knew, the Nebraska judiciary knew, and Nebraska people knew that those were big, stable companies too, and they come and go. And the people who were landowners wondered, if they go, who follows? And by the way, if they don't fail, what is it that controls who they sell this thing to, who the next owner is, who our neighbor is, who dissects our farm or trisects our ranch? And in addition to that, we have this little body of water that you don't see when you drive across our prairie, called the Ogallala Aquifer, the third largest aquifer in the world. And to give you some context for what that means, I offer you this chart from the U.S. Geological Survey. You see there, if you look closely, 3 blue balls. The largest of those is 860 miles in diameter and represents all of the water on and within and above in the atmosphere of the Earth if it were wrapped into one ball, all of it. The second sized one is all of the fresh water on and within and in the atmosphere of the Earth. And the third is about the size of Rhode Island, and that's the drinking water available on Earth. That's what Nebraskans are fighting about. We filed Thompson versus Heinemann. The legislature acted April 17, we acted April 25th. We tried the case September 27, 2013 on stipulated facts. The Attorney General wasn't in a hurry. We weren't in a hurry. We were trying to avoid condemnation. The district court decided the case February 19, declared the law unconstitutional. The Nebraska Supreme Court froze up 4-3. We have a 5-2 constitutional provision, 5 votes to declare a statute unconstitutional. But William Jennings Bryan, who wrote that, never considered this problem. What if the issue before the court is this? Is the question before us a question of constitutional law? And on that issue, the Nebraska Supreme Court split 4-3, so they were frozen. 4 votes in favor of striking the law, 3 votes in favor of holding that standing was a constitutional requirement, and we had 4. So, no decision, and we had stopped the pipeline for now into 3 years. We're back in state court. We're relitigating these issues. We went through the 2012 presidential campaign, the 2014 midterm elections, the events of the new Congress of the last month, and this is going to be an issue in the presidential election of 2016. The President of the United States could have denied the border crossing permit and stopped this project until the end of his term. 86 Nebraska landowners who are plaintiffs in this case have stopped this project for just about that same length of time, using defensively the power of eminent domain. So that's the process. I want to mention one more case. I'm off Trans-Canada now. I'm going to take 30 seconds. A month from Monday, the United States Supreme Court will hear for the second time Horn versus the USDA. It's a California raisin case. I had the great privilege of trying it in the administrative law proceedings. I'm not handling the appeal in the Supreme Court. It's an eminent domain case. It asks whether the rules of eminent domain extend to personal property involving an extraordinary rule of federal regulatory law affecting raisin producers. Pay attention to it. Professors, you're going to be teaching it. It is an awesome case, and it will have an impact that someday, in a decade, you'll have a post-Horn conference about. Thank you.
Thank you, and wow, what a great panel. And we should all thank Professor Bethany Berger for putting this conference together, because every panel has been fabulous. So thank you. So with that, we do have a few minutes, maybe 10 minutes for questions, so we'll probably take a few questions, and I don't know if anybody has one up their sleeve. Now, there's one in the front here. Yes, Mr.
So Tim Hollister talked about a case in Middletown, and that case, the way you describe it, is exactly an example of what I talked about of using eminent domain when there was no holdout or assembly problem. And so it failed on procedural grounds, but if the court had, as per economist's recommendation, used the proper rationale for when to use holdouts, it would have been an easy case. Now, there may have been a close cousin to the holdout problem called the hold-up problem, but I would argue that in that case, the would-be beneficiary of the taking actually put themselves into the position of being held up because they didn't acquire enough land in the first place for, it sounded like a parking garage or something. And so it sounds like there was very little ground in that case, no matter how you argued it, for use of eminent domain. That was just a comment.
I think that's correct.
There's another question. One of our students.
We talked a little bit about the state law changes that have been enacted, and there was a bit of touching on the municipal powers and the use of eminent domain. Have any states' legislatures removed the municipal power to conduct eminent domain proceedings and to where it's solely back in the state legislatures?
I don't know with specificity. Are you aware of that? NCSL, the state legislators.
I don't
track
think
that.
so, but a bill that would have that effect has been introduced in a state. It just came up on my kind of an eminent domain feed, so I'd have to get back to you on what state it is. I have no idea what the chances of success would be, but to my knowledge, there's no state that has withdrawn that power from municipalities yet.
Great. There's another question in the back.
Lee Howard from the Day in New London. Came all this way to talk to you guys, and Clark, I was curious, the whole case in New London became attached to the Pfizer property, and I think someone mentioned that under the new regulations that have been passed since then, there cannot be a specific company that would benefit in advance of a property being set aside for eminent domain. So I'm just wondering, the fact that Pfizer was involved in this early on, was that a violation at that time or not?
Well, certainly the courts didn't think so. We certainly made the argument that the eminent domain project in New London, in the Fort Trumbull neighborhood, was really tailored to the, and I use this word, it comes from actual correspondence between a Pfizer executive and Claire Gaudiani, who was president of NLDC, for the requirements that Pfizer had, not desires, not requests, not interests, but requirements. And so that was a big part of the case, a big debate about whether this taking was primarily to benefit Pfizer. But I will say this, I mean, in fairness to the people who supported the taking, at that time, I think it looked like the fortunes of Pfizer and the fortunes of the city of New London were inextricably joined, and that anything that was good for Pfizer would necessarily be good for the city. And so I think that's part, frankly, of the problem of the standard that the Supreme Court proposes in KELO and that other states have proposed either in legislation or in court cases. How do you disaggregate those two? How do you take them apart? It may well be true that the fortunes of New London and the fortunes of Pfizer were tied together, but so saying that, you know, eminent domain is only impermissible if it's primarily to benefit an identifiable private actor, where does that leave you? I think that's what was going on in Fort Trumbull, but I also agree that if Pfizer had, you know, followed through with its plan to expand its research facility in that site, that probably would have been beneficial to Fort Trumbull, but we know that didn't come to pass.
I would add that I think the New London Development Corporation was sort of a firewall between between Pfizer and the city. I mean, if you didn't have the NLDC in the middle there, and Pfizer dealing directly with the city government in London, I think it would have been a harder case.
Professor Garnett.
I have a question for David. So I find this litigation fascinating, in part because, I mean, I actually think Justice Thomas would say, or arguably, that the pipeline, it's okay to give the pipeline the power of eminent domain because it's a common carrier. And that's long been established. Maybe, I mean, it's utilities, railroads. I mean, these people have all abused their power forever, and it's a problem, not just in the economic development context. But I wondered if you might think, I mean, I wondered exactly what is your argument, and if you win, are there implications for sort of common carrier takings in other contexts as well?
Well, the statute that the legislature passed in 2012 provided a bypass for a class of crude oil pipeline carriers consisting of all of those who had pending with the State Department or the White House a presidential border crossing permit. And so that was the class. And so the idea is that in that class, if you can get yourself inside of it, then you don't have to go to our Public Service Commission. You don't have to qualify as a common carrier. You just have to ask the governor to issue a permit to you. So our challenge to the state statute is on state constitutional grounds because of the bypass of the Public Service Commission. Our Public Service Commission is a constitutional organization of equal rank with the governor, created by the Constitution, and its powers can be limited by the legislature, but it's a constitutional body. So we will eventually win on the merits. The law will be stricken, I think, and we'll start over. And then for the first time in Nebraska, we will have ripe the question, is TransCanada taking for a public purpose? 35 jobs in the country, 7 would be in Nebraska when it's built, that's all. And there will be no on or off ramp in Nebraska for anything that it carries. So that's all down the road. We'll have fun with those issues in the future.
Great. I think we have time for one last question. I think I see one in the back.
I got a question for Attorney Hollister. You were talking about the municipalities having all these requirements. Does CONDOT have the same requirements to a private individual?
The question is, does the Connecticut Department of Transportation have the same requirements, procedural requirements as municipalities? And the answer is generally no. I mean, almost every state agency in Connecticut that has the eminent domain power operates under its own statute. For example, schools and school boards have eminent domain power that's completely under Title X. I'm drawing a blank on which part of the statutes is the DOT, but all the state agencies have either their own statute or a group of statutes, so the answer is no.
Just add one thing.
Sure, absolutely.
I have to add this. So there's been a sense that that the KELO decision maybe wasn't so bad for eminent domain. It actually was. We have a publication opening the floodgates. There were about 6,000 condemnations or threatened condemnations in the year afterwards. David P. told us that more people lost their homes to natural disasters in 2005 than to eminent domain. Does anybody remember what happened in 2005? It was Katrina. The 2005 Atlantic hurricane season was the most active in recorded history. The impact of the season, or in recorded history, shattering numerous records, and it caused about $160 billion in property damage. So I don't know exactly how many people lost their homes in the hurricane season of 2005, but it was a lot. And a lot of people lost their homes through eminent domain. It has gotten better, but there's no question that the Supreme Court's decision was perceived as a green light by people who had been waiting to take homes through eminent domain, and they did.
If I could take just one quick moment on that point, because I did spend some time talking with Scott Bullock on this years ago. Actually, when you dive into the numbers actually drop precipitously. I think there were higher, like 90% were more threatened eminent domains. I don't think there were actual actions. I think the actual actions were significantly less than what was picked up.
We view a threat as nearly as bad as the use of eminent domain, but your point is correct.
Sarah, I'd like the last.
Absolutely. Let's all have last words. Perfect.
No,
I'm grateful for it. It's
I would
bringing
like the
some of
last
these things
30
together.
seconds for comic relief. For many years, my family would send out a year-end holiday letter, and when I was preparing for today, I found our letter from December 2005, and it was a multiple-choice test, and one of the questions read as follows. This year, Tim was very involved professionally in a process in which heartless government officials evict helpless citizens from their cozy little homes in order to demolish them and turn them over to large, wealthy corporations. This process is abbreviated ED, which stands for A, everyman displacement, B, erectile dysfunction, or C, eminent domain.
There you go. Attorney Domina, any last words? Any last words from you?
Go in peace.
And there we have it, your afternoon panel. Let's please thank them. They've been so great.
So thank you so much. for coming, and thanks again to all the panelists. This is a panel, oh, I am not Stephen Ross. Stephen Ross had a car mishap and he could not get here, so we actually, yes, so of the 4 mishaps we had in this panel, only 2 were prevented from coming here today. I mean, on this panel, this conference, so that's good. But this is a panel that I'm really excited about on eminent domain and disadvantaged communities. And I think one of the most compelling parts of the KELO opinion was Justice Thomas's dissent, talking about the ways that eminent domain has significantly affected groups that are disadvantaged in some way. And as people up here have written about, as Professor Garnett has written about, often in eminent domain, the question is not necessarily constitutional law, it's political economy. So those without political power, how does it impact them? And our panelists will address this in different ways. So Professor Debbie Becker in the sociology department at Barnard College, Columbia University, has written this fabulous book about her really in-depth research on eminent domain in Philadelphia. Often we lawyers talk about the law, give anecdotes. We don't look at the details. How does it work across the board? And she really gets a very different perspective by doing this. We had hoped to have copies in the bookstore, but they didn't show up. If you want a copy, there are forms down at the front table, and here you can order it online. She will give you a virtual signature as opposed to a real signature like I got. It's a prize-winning book. And then we'll have Professor Thomas Mitchell, who's a professor at University of Wisconsin Law School, who's done really interesting work specifically on the compensation issue in eminent domain, but also in other kinds of forced sales. He is the drafter, the primary drafter, the reporter for the Uniform Partition of Heirs Property Act, a way in which through private law means there's a lot of forced sales, which is now being adopted and considered across the country, which is wonderful. And then we'll have, I was going to say professor, sometime professor, Phil Tegler, a great friend of the law school, now the president and executive director of the Poverty and Race Research Action Council, and formerly the legal director of the Connecticut ACLU, also at the Connecticut Fair Housing Center, right? I didn't see that on your bio, but that's part of it. And has written wonderful things about public housing discrimination and addressing poverty in a systemic way. So with that, I'll turn it over to Professor Becker.
Thank you. Can you hear me? Okay, all the way in the back? Okay, great. Let me know if that changes. And I want to thank Bethany Berger and Liz O'Donnell and everyone else at the law school who organized a terrific conference, and all of you, especially the ones who are staying till the very, very end of the day. Give yourselves a big, yeah, of course. Well, that's why I'm thanking you. So the last speaker brought us to Nebraska to talk about pipelines, and so I want to apologize in advance. I spent all day yesterday on 3 planes coming in from Montana, and all morning trying to get back into this because I'm actually spending the year now researching property for oil and gas development and transportation. So if I start talking about mineral rights or oil for some reason, just tell me to stop. So as Bethany mentioned, I'm a sociologist, and so what I do is a bit different from what law professors or the practitioners that you've heard mostly from today do. And this book that I've written on eminent domain in Philadelphia is what I'll be talking about today, and it's based on a study that took me several years. I looked into eminent domains, specifically only eminent domain for private development, and looked at how the city of Philadelphia, every case that the city of Philadelphia did over 16 years in the 1990s and 2000s. So this was essentially a study of eminent domain for private redevelopment before KELO. And so many people are here today, I think, because they're concerned with with a problem, what they think of as a problem, what we think of as a problem, perhaps a tragedy, a seeming abuse of government power. And especially our panel is thinking, and many people often think, that they're worried because it's an even bigger tragedy that eminent domain for private redevelopment is suffered all too often by poor people, by people of color. And there's good evidence to suggest that that's true. But that shouldn't really be surprising given the history of eminent domain and urban redevelopment. The association isn't coincidental because the state laws that enable eminent domain for economic development or for private redevelopment are often urban renewal laws or urban redevelopment laws, first written in the 1940s and 1950s. Now, and so municipal powers for eminent domain for private redevelopment are often justified by urban redevelopment or blight. Now, I'm not going to take a side of government, and I didn't take a side, I don't think, on government side or the libertarian side. What I was more interested in, and I'm still interested in, is what are the people who are living in these neighborhoods that get where eminent domain is used or threatened, what do they care about? What are they asking for? And so what I'm going to argue is that the solutions, some of what we heard in the last panel, the reforms that were passed at the state, mostly at state level, in the years following KELO, were driven by misguided notions of what the problems were, if we want to be guided by what people in these neighborhoods care about. So in the last panel, people sort of bucketed the reforms in different ways, and I'm going to bucket them. So state laws, I put them in two groups. One, they defined blight more stringently, so made it even more difficult to say that a neighborhood was in need of redevelopment. And I say that's a problem because what it does is I'm not the only one who said this. It concentrates the problem on the poorest, but it doesn't do anything for those neighborhoods that we might really consider as blighted. And the other kinds of prohibitions on eminent domain for economic development or restricting what public use does, I think really misses the problem of neighborhood conditions. So it ties government hands from using eminent domain to actually address the poor neighborhood conditions. So I'm going to, the solutions that I offer in the last chapter of my book, and that I'll talk about more specifically at the very end of this, are to separate what we think about, first of all, separate the kinds of properties that are being addressed and the solutions based on what kinds of properties we're talking about. And so we might think about some properties as abandoned or having no value or negative value, as some of the speakers have talked about today. And actually, taking should be easier. We should make it easier for government to take those properties for private redevelopment. And yet, the valued properties, notice that Clark Neely, when he talked about taking, said a home or a business. I don't think he said property. But most of these are probably not homes or businesses. They're properties. So I want to say, so a valued property would be a home or a business, a property that someone is actually using as a home or a business. That would, by definition, make a property someone probably cares about it. So for those properties, I have a sort of list of different kinds of reforms to make, to restrict, make it harder to take those properties, including compensation, voices in planning, and accountability for the changes that are actually promised. Okay, so, clicker. And so I want to say, and the kind of argument in the book that I'll give you a little taste of here is we could think of property differently. What people at least in the city of Philadelphia, and I think more generally, we could think of them thinking of their properties as investments. And we can think of what they expect government to, one of the things people expect government to do is not to protect title, but to protect an investment. So a property that people, and I mean investment of all kinds of value, so labor, time, emotion, and money. And so when a neighborhood declines, people's investment, they don't feel that their investments are protected. They lose the value of their investment. And government has failed. And so one of the claims people will say, well, it's government's fault that the neighborhood got blighted in the first place. And then government comes and makes it worse by taking my property, the people who are left, for instance. Okay, so let me show you what this means. So first of all, I want to sort of take a step back and say, let's think about the interpretation of the problem that the Institute for Justice gave us, and then the Castle Coalition. So this cover from a Castle Coalition publication suggests that eminent domain for private redevelopment is government theft.
So it shows us that a definition of a problem is a violation of the property security, right? That taking for a private use from A to B, rather than for a public highway or a public park, that's the problem. And there we know, as we've heard over and over again today, broad public sympathy for this framing. Not only did the general public jump on board, the NAACP jumped on board, so we had the left and the libertarians joining hands around this framing of the problem. Now, this sympathy was generated around a story of Suzette KELO and Wilhelmina Dairy. And this should seem a little fishy, and I think it does to people, because the figurehead of this movement is pretty atypical from what we know about who eminent domain for redevelopment actually usually affects. So from this story, we have a white woman. Her house is well cared for. And by the time we hear about it, all she wants is for government to leave her alone. But as a sociologist, I don't think that we can understand how, and as Bethany mentioned, how policies or laws work from studying only the controversial or anomalous cases that get picked up by the news or even that get litigated, much less get to appeals courts. We know these are the anomalous cases. So what I did, as I mentioned before, so I looked for evidence by looking at all property takings for private reuse in the city of Philadelphia, Pennsylvania, from 1992 to 2007. And I did two things. One, I did a citywide census, so I sat in the redevelopment authority and used their papers to create a database of every single property that was taken, compared it to databases of other existing databases of privately owned properties in the city. And then I looked more in depth at two controversial projects, locally controversial, not nationally controversial. But some of the most controversial projects in the city during that time that involved taking over 100 properties each. Okay, so I'm going to give you a little bit about what I learned. So this is a map of Philadelphia that the darker colors represent neighborhoods. So this was an independent study of neighborhood conditions, including market value, occupancy, building conditions, things like that. So the darker colors represent the more devastated neighborhoods. Now, basically, if you're thinking about what did the census of eminent domain show me, that most takings occur in the poorest neighborhoods, and they are of vacant and abandoned properties. And most takings are uncontested. No evidence at all of opposition. The contested takings, however, so what we think of as the conflict-ridden cases, are more likely to happen in neighborhoods that we think of as in a transitional state, possibly subject to gentrification, and they involve projects that look like people are getting something they don't deserve, so larger corporations or market rate housing. So in those cases, in the cases that are routine and uncontested, what I think is going on is properties that are being taken are properties that are of no value, to little value, or negative value to anyone, but the transfer promises value to the neighbors if someone starts to take care of them. And the contested takings actually take something of value to people, and also often promises value that people don't seem to deserve based on their investments. They're either from outside or they're for-profit corporations, et cetera. So let's look at the numbers. So this is just a basic chart of pursued, not taken, or what has been called today threatened. So this is government saying they're going to take but doesn't actually do it. Taken but not contested. So this is basically all, if you add these three bars together, those are all of the threats that happened in 16 years. And what you see here is that almost 5,000 properties were taken for private redevelopment in 16 years. Another 2,500 were threatened but not taken, so they may have been bought. Most of them were still bought by the redevelopment authority. And then only 250 of those, was there any formal sign of contestation? Now I had a conservative measure because I basically was looking at whether it was litigated or whether the government gave it back, because that showed me that there had been contestation. There was no other way for me to see it. So it's conservative, but I don't think it would get much higher even if I had been in the office and been able to track every phone call. Yeah. No, I mean there was a declaration of taking, it was taken. No, the pursued, not taken is the threat. So if you add all three bars together, you can say those are all the ones that that there was a resolution passed by the Redevelopment Authority saying that passing the proposal, the earliest place I could find, the earliest place there was any official decision to take, which would have then started a process of sending people out to try to make offers. So that's all of, the threats are in there. Okay? So this is, now, some of you may be surprised, it's a lot of properties. And it actually represents almost 5,000 properties, is one of every 100 private properties in the city of Philadelphia. So in 16 years, they took 1% of all properties for private redevelopment. And yet, there wasn't a huge uproar in the news at all. And we see that there wasn't a huge uproar in terms of litigation. So why? Because if the problem is that governments are taking property for private redevelopment, there should be a lot more controversy. Now, why is what is, I think, because of the kinds of properties that were taken. So if we look here, the top bar shows you the kinds of properties taken. This is about what kinds of neighborhoods they were in. So 4 out of every 5 properties was in what were designated as the worst neighborhoods in that independent study. Another 14% were the second worst. So 98% of the properties were in Philadelphia's worst neighborhoods, even though in the city as a whole, there are only 2/3 of the properties in the city were in those kinds of neighborhoods. Similarly, if we look at what condition the properties were in, 90% of the properties were either empty lots or vacant buildings. Actually, 8% of the properties were occupied buildings. And if you look at if you can look more closely, so it's much more likely a property is going to be contested if it's actually occupied. And yet, when we talk about, when people talk about eminent domain again, they'll say a home or a business, but most of these properties are not currently homes or businesses. Okay, now I want to jump to talking about, so that's to show you sort of what does the routine taking look like. So again, the routine taking looks like government taking a property that was little of no value to anyone at all at the time, and there's a promise of increased value, and I mean all kinds of value if a new owner takes it over. So there's not much contestation. But when we look at even when we look at the conflict, and I want to mention, on my notes here, I forgot to say. So I also talked to Scott Bullock as I was doing my research, I think around 2007, I have to look at my footnote. And I was talking to him about the properties in Philadelphia, and he said, they're not that, and they were involved, but not that involved in Philadelphia. And he says, quote, there's not a whole lot of opposition for taking the truly abandoned properties, right? So they understand that. So that wasn't what they were going after. Okay. So now to the contested cases. So this is actually an example that, not the vacant building, but the one on the left, is the kind of property that would have drawn a lot of contestation in Philadelphia, not Suzette KELO's much more well taken care of house. And so in this case, what I want to say is that through the conflict that ensued, Joanne King and her family, this is Joanne's house, it shows you that they ended up actually quite satisfied, and I think it shows you what needs to happen when properties are valued by residents, because though you may think that's not a very nice house, they valued that house quite a bit. And what needs to happen is compensation that accounts for the longevity of the time that the residents have been there and their attachments to the house and neighborhood. They need to be involved in the planning for the redevelopment, and there needs to be accountability for the results that they're planning. So it needs to, what they say is going to happen needs to happen. Now, all of this happened to the Kings in a project that was called Jefferson Square. So at first, they were treated like they only deserved sort of the minimally required protections in law. Government was going to give them what was required under the federal regulations for relocation. They were going to have to move. They were going to get, I don't know, $30,000, maybe $50,000, and have to go somewhere else. And the city councilman probably, though he wouldn't quite admit it, thought of them as, I shouldn't say this on videotape, because I worked up very carefully what my words were in the book. But I think others thought that he wouldn't have said this, but others thought that he just thought of them as drug dealers and slumlords who needed to move out. So what happened was somehow they then became through their organizing, became understood as homeowners with attachments to this neighborhood who deserved to be recognized as such. And so instead of planning for a hospital parking lot for the vacant hospital to replace their houses, new housing was. They regained a plan for new housing instead. They also were compensated instead of a house somewhere else. They got new keys to some of those new houses worth several times, over $200,000, what these houses were worth. And they got security because they phased the construction and didn't make them leave these houses until they had keys to their new houses. So this is a picture of Joanne King and her new house. This is a picture of David Jones, another neighbor, homeowner who got a similar new house. This is a picture of some of the new houses and a renovated, part of the hospital renovated for senior housing. Okay, so then by contrast, the other conflict-ridden case that I studied, things went in the other direction. At first, people were more supportive of this case, and then it shows you how when government doesn't provide any of these things, people are pretty dissatisfied and consider this a case of eminent domain abuse. So in this case, the house on the left, again, not the vacant one, was the house of Manuel Velez. And he was also, I think everyone who knew him would agree, a committed homeowner with a really strong attachment to where he was. He was from Puerto Rico. This neighborhood was Puerto Rican, where the other neighborhood was mostly African American. And he loved, you'll see there's a lot of vacant land around his house. But for several reasons, he was treated like an uncommitted homeowner, and that never changed. An uncommitted tenant rather than a homeowner, and that really never changed. So he wasn't compensated for his true investments. He actually didn't have the title to his house, although everyone knew he was the real owner. He had put the title in his brother's name because he was worried that if he had an asset, he wouldn't get his Social Security. So this meant officially government had to, the redevelopment authority compensated him as a tenant and compensated his brother as the owner, and then his brother gave him the money, but that still doesn't add up to as much as what you would get if you were a homeowner. So he got less than even all the other people in this project who also did not feel like they were compensated well enough. And he had made these improvements to the lots next door, even though he didn't own them, and he thought he deserved, and everyone agreed, he deserved compensation for them as well, because in this neighborhood, and including fencing the whole block, he didn't think he deserved this for the whole block, but this is to show you this was common in this neighborhood because fencing was considered an investment, an improvement, because people were they were keeping out noxious uses, drugging and other kinds of things and dumping basically. So in this case, the American Street case, none of the things that needed to happen actually happened. There was not the compensation for the commitment, there was not the involvement in the planning, and there was definitely not the accountability for the future use. So this is Manuel in his new house that he's not happy with at all, feels crowded, incredibly crowded and dirty. This is the block after, not a great picture, but the block many, many years later, still undeveloped. Okay, so in conclusion, to bring you back to what I said were my sort of recommendations based on this idea that what people in these neighborhoods actually told me that they were looking for, I think, if I sort of summed it up to try to understand all these different kinds of cases, is that they're looking for government to protect their property as an investment. They want government to, and I don't mean just a financial investment, but including a financial investment. So government protect the value that all the kinds of values that they put in their properties. And so to do that, government needs to be able to, even more easily than it can now, at least in Philadelphia and Pennsylvania, take abandoned properties. And you'll see there's movements for land banks are for this purpose, for instance. The restrictions, I want to talk a little bit more about what the restrictions for valued properties that I recommended include, and many of them have been mentioned today. So one is to actually increase the limits on relocation compensation that are in the federal regulations to make them much higher, especially for businesses. Another would be to actually account, many people sort of who don't have legal training have come up to me and said, of course they must account for the years you've been there, right? I'm sure they compensate for that. So it wouldn't be that hard a thing to compensate for longevity as a representation of someone's investment. As well, you could compensate, as has been mentioned, for the value of the assembly, for the value of the future use instead of the current market value. In terms of getting people involved in planning, I haven't heard actually these recommendations as much. So one would be there are real problems with transparency, not just transparency of the planning, but transparency of these individual deals of compensation. That's a real problem. If people don't know what each other are getting, and it creates it's more likely that people are going to feel like they need to do this alone rather than organize because of a lack of transparency, because this is treated like a private deal. I also talk about having government-funded individual advocates, such as we already have for children, guardians ad litem, so people who really are professionals at eminent domain helping the individuals, as well as, probably the most controversial recommendation, publicly funded community organizers. So the projects that actually do get somewhere have good organizers, and I think that's what we saw David Domina is serving as in the case in Nebraska, but it doesn't always need to be a lawyer, and it needs to happen well before litigation. Well before litigation can even happen, because in these cases, it can only happen once the taking occurs, and not as likely to happen in cases that are not as big as the Keystone. And then finally, accountability would include things like a right of first refusal if at some point down the road, this was also mentioned before, if the plan development doesn't happen, as well as involvement on what the new plans would be. And then I think the sort of last thing I'll say, because I think my time is up, is to notice that all of these reforms could be equally useful, even if the takings were for a basically accepted public use, even if they were for a highway or for a park. My sense from the little I can find out there is that there are actually numerically many more takings for those purposes than there are for private redevelopment, and those people are much less likely to get public support if they can't mobilize support around this anger about a private use. And yet they suffer many of the same ills. Okay, that's it. Thank you very much.
So I too want to thank Bethany Berger, Liz O'Donnell, and the other students who were helpful in the organizing, and for the remaining remnants of folks here who have decided to stay on for our panel. I really appreciate it. Bethany, I do have one issue to take with you in terms of having me speak after Debbie, because what else am I going to say, right? So I'm just going to say thank you, and I'll sit down. I guess I couldn't justify myself here. All right, so what I'm going to try to do is kind of, the focus obviously here is the 10th anniversary of KELO is eminent domain. I'm going to try to pan out a little bit more when we're talking about poor and disadvantaged people and different types of forced sales that have had a disparate impact in these communities, right? So obviously in the housing crisis, we've seen that, obviously many people lost their homes as a result of foreclosure. Disproportionately, those people were people of color, and including folks who had good credit, who were essentially what we called steered into subprime loans, right? And so there's a lot of evidence that in terms of African Americans, Latinos, and other people of color, that they were steered into these loans. Obviously, also in terms of kind of at the level at the USDA and farmers, we had a series of class action lawsuits brought against these USDA for being discriminatory in their administration of loans to minority farmers and to women farmers, and in some governmental programs which resulted in a lot of these farmers being driven into foreclosure. Tax sales, right? So we have, tax sales could impact people generally. They've had a disproportionate impact on homeowners or property owners of color. In some cases, you have properties that are rezoned. They're then assessed at for the highest and best use. But as Dwight indicated earlier, even where there has not been a rezoning, sometimes the tax assessment is based upon the probability of rezoning, right? So earlier we talked there was a statement made that, well, does any homeowner have to use their property for the highest and best use, and will we use eminent domain if they don't? Through the property tax assessments, people are being taxed at the highest and best use, even if they have a completely viable use, a residential use that might not be that highest and best use, which actually makes it incredibly difficult for a lot of these people to hold on to their homes. Secondly, there's some evidence that properties that are of low value and disproportionately owned by people of color There's a law professor at University of Memphis Law School, I think Lee Harris, who did a study in one municipality, and in his study it turned out that properties that were of low value were overassessed, and higher value properties were underassessed, right? Once again, making it difficult for disadvantaged property owners to maintain their homes, right? And then you also have an indication in certain jurisdictions where there have been primarily minority areas of town that in the aggregate have been overassessed, and primarily white areas that have been underassessed. There's a really fascinating historian who's leaving Marquette to join the University of Virginia, Andrew Carl, and he's doing some work in the South, including in Mississippi, where the tax assessors have specifically punished African-American landowners who have exercised or challenged the government in terms of seeking to have their rights vindicated, and essentially the tax assessor has punished them by jacking up the assessments on their homes. As Bethany referred to earlier, I know a little bit about partition. I was the principal drafter of this Uniform Partition Act. So, you know, for the non-lawyers here, tenancy in common is a common form of ownership. It's a common ownership form, oftentimes owned by families. In states throughout the U.S., minority property owners have disproportionately had court-ordered forced partition sales, even in instances where the courts easily could have divided the land and then distributed it to various members of the common ownership group, which is supposed to be the statutory preference. Not only have these owners lost their land as a result of these court-ordered forced sales, oftentimes these sales are justified that the property as a whole has economies of scale and it will maximize wealth to sell the property. What most people have overlooked is that in almost every state statute, in terms of the procedure governing the sales, they indicate that the procedures used for a sale upon execution, which is a type of forced sale that is well known to result in a below market or fire sale prices, has resulted. So not only have people lost their property rights, they've been stripped of significant wealth in the process. And then we'll talk a little bit about kind of eminent domain. Right, so kind of as Debbie had kind of indicated, I mean, we're here because of KELO, but as Debbie indicated, KELO is an outlier case when we look at kind of the history of eminent domain over the last 6 or 7 decades in this country, right? So we have the obvious problem that minorities tend to be vulnerable because they lack political, economic, and legal resources, and these are just some examples in terms of in Berman versus Parker, 97% of those residents who lost their homes were black. During the period of urban renewal, you had in 1949 to 1963 in this data set, you had 2/3 of the people who lost their property were minorities, right? And obviously we have a number of public works and highway projects that disproportionately impact the communities of color. So from one perspective, not only was kind of KELO, when we talk about the difference between the reaction among the professoriate, maybe the practicing bar, seemed kind of uneventful in terms of just what the law was. But I think in many communities of color, their reaction was, well, why this case? Why, after this history of so many minority property owners losing their property with no public outrage, why all of a sudden now this public backlash, right? And so we talked a little bit about, kind of blight abuse. So just in terms of kind of one example, University of Chicago in the 1950s and 60s actually had disproportionate power in writing some of the eminent domain laws that applied to it in Chicago. And they used it essentially to force a number of the people who had been living in the neighborhoods where University of Chicago is, Hyde Park and Woodlawn, out. This resulted in many African Americans being displaced, and it resulted in a number of kind of businesses, including jazz clubs and blues clubs. There used to be on 55th Street a whole cultural corridor that was kind of eliminated. once again, I think that the people who have looked at this have said at the stage that the University of Chicago stepped in, there wasn't true slum conditions. Some of that, what had been the slum conditions, had been addressed prior to the time that the University of Chicago was able to use this. So we look at in terms of then, we have KELO, we have this kind of public backlash. It's framed very much as kind of as a core attack on private property rights. But in some ways, what we see is in terms of, we've talked about all of this law reform, even though it's, in terms of the 47 states, we have it in 3 different baskets based upon the strength of the reforms. But almost all of these reforms, with a few exceptions, deal with takings for private economic development. A very small, much smaller number has dealt with blight, right? And in terms of the kind of the blight analysis, a lot of it has been diluted, and I'll show you an example. One has been repealed in Louisiana, right? So let me just kind of show you. So this is so this was after Hurricane Katrina in New Orleans. We had a neighborhood called the Mid-City neighborhood, and there had been this kind of famous, iconic hospital, Charity Hospital. It did get flooded, but then New Orleans and the state of Louisiana used this as a pretext for saying what they needed to do was demolish this hospital, build a new hospital and VA center, right? And all of the kind of economic analysis of different engineering, or some of the consultants who had been hired, actually said no. It would actually be much more cost efficient to renovate, remodel, rehabilitate the Charity Hospital than it would be to buy this new hospital, to build this new hospital. Well, what did they do to build this new hospital? We're talking about a 27-block area, and Mid-City is right off of kind of downtown. 249 buildings, 65 part of the National Register District, right? This is a typical home in Mid-City. A lot of huge jazz giants grew up not far from here, including Louis Armstrong. And this was in the context of a Louisiana statute that had banned eminent domain for private economic development. The only basis was blight. And by the time this proposal had come along, the limited statutory reform, which basically what Louisiana did was both outlaw eminent domain for private economic development, and then in terms of eminent domain based upon blight, they indicated that the property owner could essentially buy back their property at its new market value, taking into account the prospective development. Well, the municipality didn't like that, and it was seen as kind of a barrier to development. So within a year, Louisiana repealed that very diluted, enhanced blight protection, was able to label this 27-block area as completely blighted, and there was some local activism, but I suspect most of you, so if you were in New Orleans, you would have heard about this Mid-City controversy, but it didn't generate huge amounts of support within the city. It was within this neighborhood, and I suspect most of you here have never heard of Mid-City, right? So if KELO, we're talking about 7 individual private property owners, and it generates this huge backlash all across the country. How is it that we have this neighborhood with its 265 properties, 165 on the National Register, and most of you, I assume, have not heard about the conflict? The area has been totally leveled, and I guess the buildings of the hospitals is proceeding. Oh, right, I got to get on. All right, so one thing that Bethany indicated is I have done a little bit of research, nothing like Debbie here, in terms of the racial impacts that flow from eminent domain, kind of challenging this assumption. I think many of you have made comments today, other panelists, that despite the constitutional requirement of a fair market value compensation, that a number of empirical studies conducted by real estate economists show that people across the board don't get fair market value. What we see is kind of a bifurcation. Properties that are higher value tend to get a premium above fair market value properties, and property that's low value property, those who own it, tend to get a discount. One study in New York, for example, studied eminent domain over a 10-year period. It showed that only 7% of the property owners actually got a payment that was about the fair market value, but 40% of the payments was what they called was extreme compensation, either 50% more than the fair market value or 50% or less of the fair market value. And in that data set, in the aggregate, that all the properties aggregated, the compensation represented 23% less than the fair market values for those properties, right? In this article that I am referring to, this article I published in Florida State a couple of years ago, what I kind of theorized was maybe even if you had property owners who were otherwise similarly situated but were of different races, perhaps the minority property owners, if we correct for income, would do worse than a similar situated white property owner. Now, I had a case in Madison at this very time I was writing the article, and essentially what you had was one exercise of eminent domain by the University of Wisconsin that got basically condemned this incredibly popular bar on campus, wanted to use it for a new music school, which the groundbreaking is going to take place pretty soon. The university offered the brothers who own this bar $2.1 million. It turns out the property had been assessed at $700,000. This case in Madison was kind of the Madison version of KELO. All over the media, first of all, the claim that taking it for use as a music school didn't constitute a public use. But then the second argument was that they were being totally screwed economically. And I've often kind of said, if you want to pay me 3 times the value of my property, I might take, anyway, so I digress. At the same time that this action was going, literally 2 miles away in a predominantly minority neighborhood in Madison, the city wanted to acquire ownership of 4 buildings that had been used as apartment buildings to build a senior center. The landlords were 4 minority landlords. So in their case, their properties together had an aggregate value of $2.1 million. The city offered them $700,000, right? No mention. I think there was one article in the paper once on the back pages, and just no attention to this, right? So now the difference in my case is the owners of the bar and the owners of the apartment building were not similarly situated income-wise. So we certainly know that there was disparate treatment, but we don't know if we corrected for income how great that disparity would be. All right, so then just in terms of my last slide, Bethany, I see you out of the corner of my eye here. I think in terms of, with respect in these neighborhoods, right, I think Debbie's mentioned it, a lot of people mentioned that in terms of blight. I mean, from the standpoint of many of these communities, yes, the definition of blight does need to be tightened a bit, so that a neighborhood like that mid-city that I showed you in New Orleans, I think most people would not, in their visceral sense, look at those types of properties and think that represented a blighted condition. But sort of like what Debbie was kind of indicating, I think in many of these communities, some people have said, no, we should go further than that, right? So the state of Wisconsin has gone further, so they say not only did they tighten up the definition of blight, but they indicated that in an area that they want to redevelop, if they're going to use eminent domain, every single property has to be deemed to be blighted. I think in certain of these poor and disadvantaged communities, people on the ground would feel a little bit different, right? Nobody is arguing that these neighborhoods are wonderful neighborhoods. I think most of the people would actually like a redeveloped area, but a redeveloped neighborhood where they would actually capture some of the benefits of redevelopment. whether that meant sharing the profits, as we had a discussion earlier, whether that meant community benefit agreements. So trying to work out where the right of an individual private property owner in these neighborhoods should take a little bit of a backseat to benefit the community as a whole, right? We could have a whole discussion about that. I'm not going to purport to draw any lines here, but I do think that that makes those communities a little bit different than the community that Suzette KELO and others lived in New London. So I think we would have to have kind of a different policy analysis in how we address those communities and how we figured out where the right place for eminent domain was.
All right, it's the end of the day. I'm going to be really radical and stay seated. I was struck by one of your slides there, the statistics on Berman and the percentage of people of color who've been impacted by eminent domain and urban renewal. I said, he failed to cite Justice Thomas's opinion in KELO in that slide. And then I pulled out Justice Thomas's opinion in KELO, and on the same page, right at the end of that paragraph, he cites you. So you're off the hook for that. It's like, okay. Yeah, I think I'm not an eminent domain expert. I'm a civil rights lawyer with a background in housing policy and fair housing. And the striking thing about this issue is that this extraordinary constitutional expansion of the eminent domain power came on the backs of African Americans living in Southwest Washington, D.C. In the initial federal law, federal urban renewal law, and the final litigation and green lighting of that law. And that's really what's led to the precedent that we're talking about here today. And in KELO, we had a powerful dissent on this issue from Justice Thomas, of all people. I took from my text also the really excellent amicus brief in KELO submitted by the NAACP. And the tradition and the targeting of underserved areas, usually predominantly minority, and the undervaluing of those areas, as we've heard over the course of the afternoon. So this phenomenon raises the question for me of, why isn't it possible to attack or challenge eminent domain on racial grounds? Of course, that did not happen in KELO, as I think Professor Mitchell was very politely implying. But could it happen in other contexts? And the answer, interestingly, is yes. A cause célèbre case 2 or 3 years ago in Mount Holly, New Jersey, was in fact a fair housing racial challenge to an eminent domain taking in the central New Jersey town of Mount Holly, New Jersey. It was eminent domain based on blight under the New Jersey statute. And the facts of the case basically were, this was a 329 two-story row houses in a little neighborhood called Mount Holly Gardens. Almost all of the residents, mostly homeowners of this area, were low or very low income families. Most had lived there a very long time, a lot of elderly folks. 75% African American and Latino enclave in this rundown part of town. The only predominantly minority area in the township of Mount Holly, which was otherwise a 30% minority town. A planner working for the city designated the area as blighted, and it was deemed the West Rancocas redevelopment project plan area to be demolished and replaced with the, quote, villages at Parker's Mills, which was going to be a development of 520 townhomes and apartments with a minuscule proportion of housing available to the folks who would be evicted from the area. During the process of this land assembly, prior to the taking action or during the taking action. Obviously, a number of residents fled or sold, and there was increasing blight as a result of the city's action. Lots of vacant properties. In the district court, there was a finding of crime, squatters, graffiti, roaches, and mold generated by the land assembly process itself. This was followed by demolition, which was incredibly noxious to the existing residents, and it also led to the partial destruction of their homes, because these were row houses, so you took out the adjoining wall. Water gets in through the foundation and the roof, and that led to a lot of damage for these 70 remaining homeowners who were there at the time of the filing of the case. So this case was brought under the Federal Fair Housing Act, and it's very important procedurally to acknowledge that this is a federal civil rights statute that if it is pled properly with the proper plaintiffs, it trumps state police power. It trumps eminent domain. So it's not a defense to an eminent domain action, but it is a affirmative case that really trumps the state or local government's use of eminent domain. It was brought under a racial impact or disparate effects theory, which is what gave this case. Ordinarily, this case would not have gotten any attention because it was about low-income people of color. However, it involved ultimately a challenge in the U.S. Supreme Court to the theory of disparate impact. Theory of disparate impact basically says that you can challenge government action, in this case in the arena of housing, if the policy or practice has a strong disparate impact on people of color and there is no justification for it. And I'll get into the test in a moment. But I'll get into the test right now. Under this theory of disparate impact, once you show a statistical impact, which was very easy to do in this case, the burden shifts to the town to show that there's a legitimate government interest. And here, of course, there's a clear legitimate government interest. Well, it was contested, but the town's argument was this was a blighted area. We have this redevelopment plan. It's pursuant to our police power under the eminent domain law. And then the burden shifts back to the plaintiffs to demonstrate that there were less discriminatory alternatives. And this process of looking for less discriminatory alternatives is, I think, really provides a good lesson for eminent domain law in general. And I think it's been, a lot of the themes today have kind of gone to this question. How can you achieve the goals of the eminent domain and the taking and reduce the impacts on the homeowners and the victims of the eminent domain and the people in the path of eminent domain? And as it turned out, at the end of the day, this case was pulled out after the briefs had been written in the Supreme Court right before oral argument with a settlement at the 11th hour that basically led to an inclusive redevelopment of the Mount Holly properties. Really, I think, quite generous relocation benefits for the renters, opportunities for alternate housing for people who wanted to leave the community, and a right to return for all the families who wanted to permanently live in Mount Holly in new units. And some of them were temporarily relocated and moved back, and others were able to stay in their homes until their new home was built. And this was in the process of negotiating this civil rights claim. Now, when I was reading Professor Mitchell's article that out is cited by Justice Thomas on the page that he was citing on the slide, I was really interested to read the lower court opinion in Berman, Judge Prettyman's case, and I guess it was in the Court of Appeals. And much more nuanced than the Berman decision in the Supreme Court, it had in it this sense of, was there a less discriminatory way of doing this? He didn't talk about race directly, but he talked about looking for a way of minimizing the harmful impact of the taking on the owners. A much more nuanced way of looking at it, and resembles in a way, even though it's not a racial justice analysis, it resembles the analysis you do in a fair housing or civil rights case. And I think it would be nice to kind of go back to that decision and incorporate some of that approach in eminent domain more generally. So those were my basic comments, and I had I guess more of a question and like some discussion of this. I've been very intrigued preparing for this and thinking about it, the work we do on gentrification, or what I would call inclusive gentrification in low-income communities, where you basically have a loss of value in a community that's driven in large part by government action and inaction, affecting usually communities of color, people who have a long-time stake in the community, losing value in their property, and not getting a return on the investment when the area gentrifies. And, you know, is there a way of using eminent domain to benefit low-income folks in these communities in the context of gentrification? You know, all of the literature is about the harm and the abuses of eminent domain in the context of urban renewal. But are there ways, you know, land banking, deed restrictions on, you know, long-term affordability restrictions? Can we use eminent domain in creative ways to protect folks' stake in these communities as they start to revitalize? And I think, you know, this is especially compelling in the case of state-sponsored gentrification. It's also compelling, I think, in a place like Park Slope, where it's all like private market-driven gentrification. How can we kind of rethink eminent domain to use it in an affirmative, progressive way there? So that's kind of my question to the panel to get it started.
Yeah, thank you. So, Thomas and Debbie, thoughts about that question?
Two things. Well, I like the shift to wondering in what ways eminent domain might also be used for positive reasons. And I think it was mentioned once here, the proposals by cities to use eminent domain to stem foreclosure, problems with foreclosures and neighborhood decline because of foreclosures. I think in this case, we're talking about using eminent domain for tenants who are forced out of gentrifying neighborhoods because of increased rent. Seems like an interesting idea, and I also think that the bigger problem is also the owner, not bigger problem, another problem in gentrifying neighborhoods is how to protect owners affected by increased property taxes. I'm not sure how eminent domain can be used for that. I think it's more an issue of property tax abatements, but maybe he's talking about something else that I don't know.
Anybody else? Yes. Yeah, I mean, my experience in going to New Orleans and getting a tour of Mid-City was that it was broader than a few young people. You had longtime homeowners in Mid-City. Mobilizing folks outside those neighborhoods? Yeah. 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 Right. Yeah. So I think yeah. I mean, so I'm going to draw a little bit on my experience with this Uniform Act, and one of the things I think is that I really found most ennobling, and has given me cause for some optimism, was that you know, when I used to work on this, up until about 2008, you know, the uniform reaction I would get was, you know, hey, Thomas, love your scholarship, but then I see you're taking these reforms seriously. I mean, come on, get real. Like, this could never happen. Stop wasting your time trying to actually reform the law. Just keep writing these law review articles. They're really interesting. And I'm not joking about that. You know, so, you know, part of me is, you know, my committed sense of justice was not willing to accept that totally. And basically, there were a number of community groups, mostly in the South, some in Appalachia, who had, as their mission statement, working on this problem of these, you know, people call it heirs property, but not working in any coordinated way. And, you know, for a lot of complicated reasons, this opportunity actually came of drafting this Uniform Act. And essentially, through some of my encouragement, I basically got all these organizations on the phone and said, you know, you need to work collectively, right? Your voice is not powerful enough. And so they ultimately actually formed a nonprofit there across different regions. And they played an incredible role in the drafting of this, and they've played an incredible role in the enactment. So I look at what the Institute for Justice is doing, right? They obviously have a frame. They've obviously have a very powerful frame, and they have been effective in terms of, you know, advocating and pushing and experiencing success. So I think the same thing in terms of some of these people who are sympathetic to these is that if they're just isolated voices in the wind, they're not going to have any impact. So there needs to be, we talk about kind of assembly problems. We need to think of how could we, you know, somehow organize these voices so that they could coordinate and be more successful.
Yeah.
I want to add something really brief to this. So I don't think that every small project, every community that wants to fight eminent domain needs to mobilize an entire city or the country to change the law. They want to often want to make a good negotiation for that particular redevelopment project. So they probably do, I think, need to be able to mobilize some sympathy in a few newspaper articles. But maybe that's it. And they need to, in addition to that, have very smart political community organizers who know what they're doing politically, and some luck. And so in the case that I talk about, it was a white city council member and a black neighborhood that made it look like it was the same old, and maybe it was, the same old kind of discrimination of a black families being pushed out by a white city council member, and that upset people, and so they got some good newspaper articles that framed it that way, and then they had institutions that helped them as well, and so that may be all that is needed. Okay.
Well, I mean, you know, I want to just follow up on that point. This reminds me of, in the Mount Holly settlement, of course, not only were they represented by counsel, the civil rights lawyers who brought the case, but they had planners and people to put together the deal on their side. And they couldn't have done that complex settlement with all those benefits without having that expertise on their side. And this is, you know, it's about lawyers, about organizers, it's also about the planners. And this sort of goes to an old colleague of Dwight Merriam and mine, Paul Davidoff, who first wrote about the advocacy planning and the need to have planners who are not representing the city writing up the redevelopment blight plan, but planners working in the community for the community doing the alternative plan. And that's a key part of this, I think. And that's one of the things that really worked in Mount Holly is they had that on their side to kind of talk back to the official plans. Yeah. Baltimore's been doing a really good job of with land banking, and well, I can't say it's really successful yet, but the idea is very good. You know, it's a land banking in Pittsburgh. They're doing. I mean, it's. Explain what it is. Oh, it's basically public acquisition of, well, the way I've seen it work well is it's either being used, as in Philadelphia, as you explained, to acquire properties from private owners and then to repackage them for a better use in a really blighted area. It's also, the way we've seen it used is in areas with potential gentrification, to put together parcels to get public ownership of parcels in the path of gentrification, to basically develop affordable housing there, so to give people an anchor in that community. And that's the kind, that's when I was sort of fantasizing about eminent domain. Is that one way we could grab some of this land? And one idea I heard also, which was maybe a fantasy, but the idea of taking of the future rent value for multifamily properties and just basically paying, the owner for the right to, you basically kind of place a deed restriction on existing affordable housing in a neighborhood through the eminent domain process. I don't even know if that's conceivable, but you can imagine that kind of process. So it's a kind of land bank, but you're acquiring a kind of an easement on. I'm using all these terms wrong, but an easement on the future rent, so people can stay in place. You can also, of course, give vouchers to families in those units to let them stay in the neighborhood, recognizing the, their long-term commitment to the neighborhood. There's many ways of doing it, but I think eminent domain is like a tool that hasn't really been exploited for this.
I think the most famous land bank, early land bank that is considered the most successful is the county that has Flint, Michigan. The land bank of Genesee County has been used as a model by many other cities. Philadelphia, I haven't looked up lately, it actually didn't have a land bank. Politicians don't want to give up their power over the land. That's a problem in many places. But it has developed a different program, the Horticultural Society. So it seems not as good, but has helped a lot. So government is funding the cleanup of private abandoned properties. So the Horticultural Society employs people to go out and clean up, sort of level the property, get rid of the dump, everything that was dumped there, and put a little 3-foot fence, not for boating, but just sort of neat, and just grass, seed the area, and keep the lawn maintained, which does a lot for the neighborhoods. So just maintenance, and that's one of the things land banks do, is they maintain vacant properties. So a sort of intermediate solution is to maintain the properties without owning them.
Yeah, Phil, this is a very discrete, this doesn't really address the kind of communities you work in, but one of the other problems in the area I work in with like tenancy and common ownership is the default rules are horrible in terms of letting folks kind of reach a collective decision about what to do with the property. So the rules require unanimity. And if you can't get unanimity, then folks can't change their style of ownership, they can't make decisions about how to use the land often. So it seems to me that there's like two different approaches. One could change the law and say, no, we're no longer going to require such unanimity. But the other thing you could do is use eminent domain to allow those property owners the opportunity to consolidate their ownership into something that's a far more useful form, whether that's reorganized as a LLC, having privately negotiated tenancy and common agreements. But like I said, that's not exactly the kind of issues, in kind of poor urban neighborhoods necessarily.
It's basically handing over the power of eminent domain to the people.
Exactly. Yes.
That's shocking.
But that does run into the taking from A and giving to B problem, as some courts have decided for condemning rights of way for landlocked land.
There's a way around that too. Yeah, so this eminent domain would be for tenants who want to maintain possession in a much more stable form, right? So, yeah.
This discussion, the last two panels, the last panel, which has largely escaped us here for a moment, I really wanted to ask what changes each of them would recommend in federal, state, or local laws to address the issues we've raised here today. this panel is also equally exciting and interesting and has made me have some thoughts I didn't have before. Phil, I think that it's really hard to figure out how eminent domain can help us overcome some of these adverse impacts, but it's just occurred to me now, thanks to you, of the model of Florida's former developments of regional impact and their infrastructure requirements. And in Florida, they used to, unfortunately they abandoned it, but required the infrastructure to be in place to accommodate the impacts of development. Why not require the government to have housing units comparable to those being displaced in place and available for the people who are being displaced before they take their homes as a condition of their taking private properties for public development? The other thing that occurs to me from the discussion, and it's hard for me to discern, and we had such a great conversation last night, Deb, about whether people want to be displaced to get out of bad neighborhoods or whether they're being torn from their social networks. And, you know, I couldn't tell you one neighborhood from another which is which. But at base, the problem is that large segments of our population do not have enough money to compete in the market. And money will solve a lot of problems. And it occurs to me from your discussion, the other thing that I think I'd like to think about more, not today, but keep thinking about, is two things. One, using tax increment financing to create funds to pour over into a trust that would be used to help people displaced. Why not capture some of that windfall tax money that comes from redevelopment and divert it back and hold it, just like the land trust or land banks, but hold it for the benefit with some authority that has the right to spend it as a revolving fund to help the next project? And why not require private developers who become owners of these properties to earmark a portion of their profits or value, again to be moved to an authority or trust fund, which would then have a revolving and expanding fund to help people in future acquisitions acquire comparable housing. So thank you for, maybe those thoughts are crazy, but I'd like you to react to them. Having the housing in place and capturing some of that value. Does that solve some of your problems that you addressed in this panel?
I think that's a fabulous idea, and I don't recognize it, so it may be a new idea. We'll see. Yeah, okay.
But Phil and Dwight, wouldn't as a practical matter that face the same type of resistance that we have in terms of inclusionary zoning requirements? You know, I mean, obviously, I can't imagine a lot of developers would be happy with your proposition.
Inclusionary zoning moves downtown.
I have one point that I meant to mention that I don't believe has come up, even though we have talked about so many things all day. And that is that it seems that we have generally talked about how property owners should get more, or tenants should get more than they get, and that I think leaves out one of the things governments are dealing with, urban governments, which is sort of delinquent property owners in a sense. So what more commonly are called speculators and slumlords. And one of the reasons that they use eminent domain is to do something about those people, to do something about what they're doing to properties. So they also use other means like building code enforcements. But one of the things that happens is that they use eminent domain to try to get properties out of the hands of what we would call speculators and slumlords. And so I just want to mention that because so much of the conversation has been about getting people more protection and more money. And when this actually happens, I think the public doesn't want to give, and they want to hold government responsible for not giving those kinds of property owners more. Then they want to make sure that they get nothing more than market value is basically what I saw. Like they should get, they don't deserve to keep their property is what people generally tended to think. And if they lose their property to eminent domain, they should get no more than market value. And so I just want to add that there's a variety of kinds of property owners that we're talking about. So we've got, maybe think about the speculators and slumlords, the people who are completely gone, we can't find the owners, and then think about the people who so I don't think it's a difference between neighborhoods, but there are individuals who want to move if they can get enough money, and then there are individuals who want to stay. And so you have to figure out policies and laws that will allow government to sort of finesse that there are all of these kinds of owners and occupants.
Following up on Dwight's comments, you had one of your proposals was that there be enhanced compensation based on longevity, right? But as Dwight kind of indicated, there are some people whose property is condemned who have great attachments to the neighborhood and feel a lot of non-economic loss because of their sentimental and attachments. But there are others who feel liberated, right? You know, if you look at in KELO, the overwhelming majority of the folks who sold were happy with the compensation. I'm not talking about the plaintiffs, but who sold were happy, and many of them indicated they had wanted to get out. So would you still be compensating people based on longevity when it turns out that if they could have left 10 years ago, they would have left?
I would, for the simple reason that I think that those people would say, and they do say, they suffered. They stayed there through the hard times, and they deserve something for it.
Well, thank you. I think that's a good note to close on, and thank you so much. I'm so glad this is going to be recorded, so that it's being recorded so even more people can see it, and I think this has been great for me. So it's all about me.